arbitrator. Similarly, the second arbitrator who has been appointed, Lordship, Mr. Daman Prasad Biswas, he's also not in a position to act as the arbitrator. He has communicated to me. Sorry, Lordship, it's Subra Shankar Bhatta. Lordship, he has communicated to me through WhatsApp message that he is not in a position to act as the arbitrator because he's a member of the State Consumer Dispute Redressal Commission, Lordship. But
is a valuation of the arbitration, I mean, the dispute?
Lordship,
Approximately, I mean.
Dispute is very little, my lord.
Lordship, this arises out of development agreement, Lordship.
My lord, development agreement, I am appearing on behalf of the respondent landlord. Development agreement was entered into 20th August 2009. And
we cannot go into the merits.
No, we are not. No,
because already twice arbitrator has been appointed. That chapter. Valuation, just an idea of that.
Actually,
in lakhs or crores or hundreds of thousands?
Crores, because we have not.
No.
Lordship, we have not claimed exactly any amount. We have claimed specific performance of the development agreement, Lordship. And they had illegally terminated the development agreement. So against that, we had pleaded for arbitration, which they did not reply to our letter. So we had to appear before the Honorable Chief Justice for appointment of the arbitrator, Lordship.
Kind permission. Matter is very, very little. In the arbitration order is Chief Justice, Honorable Chief Justice order is there. The jurisdiction, arbitrator, whether arbitrator appointment and arbitral tribunal dispute can be referred. Jurisdiction matter was also referred before the Honorable Chief Justice. Matter and Honorable Chief Justice
discussed, Lordship, and been
so I'll appoint some advocate of this court, not very senior.
Lordship.
It is submitted by learned counsel for the petitioner that the second arbitrator appointed in place of Mr. Daman Prasad Biswas, namely Mr. Subra Shankar Bhatto, has also declined to take up the office of arbitrator. Next para. In such circumstances, since an appointment has already been made, there cannot be any further dispute regarding the arbitrability of the matter. Hence, AP 33 of 2023 is disposed of by appointing Mr. I'll appoint somebody. I'll just think. Sarvopriyo Banerjee. Mr. Sarvopriyo Mukherjee, I'll appoint. Mr. Sarvopriyo Mukherjee, phone ta pore diye debo, gap reke debo. An advocate practicing in this court and a member of the Bar Library Club as the sole arbitrator to resolve the dispute between the parties, subject to obtaining declaration stroke consent under sections 12 of the Arbitration and Conciliation Act 1996.
Lordship,
try your luck. Let us see if Mr. Mukherjee is otherwise.
Matter is pending since 2009.
No, ask Mr. Mukherjee today. Otherwise, we will mention it and then I'll think of someone else.
Lordship.
Well, so far my understanding, matter is very little, man. Very little. Issue is very little.
Depending on the ultimate result. Yes.
Much
Thank you.
New motions. Item number 2.
Well, this is my application, my lord, but I am feeling not comfortable today.
Not comfortable today?
Yes, ma'am.
When should I
I'm
keep it?
saying only matter may be taken up on Monday.
Please use the microphone. Matter may be taken up?
On Monday.
You're for the petitioner?
I am for the petitioner.
I am for the respondents.
An adjournment is sought on behalf of the petitioner. Accordingly, let the matter stand adjourned till April 24, 2023, Monday. Thank you.
Item number 3, Mongol Electrical Industries Private Limited versus Andrew and Company.
Mr. Ratul Das, I'm paying for a short pass
Sir?
over your lordship. Ratul Das, lordship.
You move the matter. You're for the petitioner?
Yes, lordship.
Move the matter.
Lordship, I'm not ready in the matter. I've just been briefed in.
Pass over. Pass over gulo oi purota hoye gele tarpor.
Item number 4, Sri Solai Malai Pichai Anand versus Exide
Pass
Industries.
over or you will move the matter or what?
Lordship, I appear for the respondent
Respondent.
and I
Pass
was,
over in the first call.
Lordship, I was in fact served only yesterday at 4:30 PM, whereas the application was actually filed on 13th of April.
Acha.
And they served on us only yesterday under a covering letter of day before yesterday. So,
If you're without
I'm-
instructions, I can relegate it to some other day, or I can take it up today if it's a. If it's
Lordship, I'm led by Mr. Riturputru.
Yes, but the petition is not there, so I'll pass it over in the first call then.
Lord, kindly keeps it on Monday or
Monday.
Tuesday because
Tuesday.
Very well. Like order record kuni, none appears for the petitioner
Tuesday, my lord.
at the
Tuesday,
time of
Lordship.
call. Stop. Learned counsel for the respondent submits that a copy has only recently been served on the respondent. Full stop. Accordingly, on the prayer of learned counsel for the respondent, the matter is adjourned till April 25, 2023. That
Obliged.
is Tuesday. Yes.
Extremely grateful. Thank you. Item number 4.
4 days. Petitioner? Pass over in the first call.
Adjourn motion. Item number 5. Vishwanath Das versus Suchitra Majumdar.
Yes, Mr. Raut.
Well, I am opposing the prayer.
Acha.
And
You are
in
for the
co-
petitioner? Yes.
My unfinished petition.
Yes.
Well, in compliance with the order of Honorable Chief Justice, you have exchanged the affidavit.
Regarding this section 11?
My lord.
আচ্ছা affidavits গুলো দেবেন একটু
এটা pass over হয়েছিল।
My lord,
You are filing your reply today?
my, op-
Your opposition today?
my lord, my
Very good.
identity.
পাঁচ নয়। বিশ্বনাথ দাস 6।
পাওয়া
5
গেছে?
5 হ্যাঁ 5।
পরেরটা রেডি করো অপোজিশন রিপ্লাই লাগবে
কেন opposition? Opposition.
রিপ্লাই ওটা ঢুকে যায়নি তো
এই তো reply.
yes what is the matter please
My lord, these application arises out of an agreement for sale. That is annexure 1.
you are Mr. Ghosh
I am Mr. Anand Dr.
Mr. Dottar I'll hear Mr. Raut's objection first so that you can answer it that will cut short the matter yes Mr. Raut what are your objections
My lord, my submission is twofold. First of all, my lord, according to my client, this particular agreement for sale was obtained by my licensed client by practicing fraud and misrepresentation. Because of the fact, my lord, that the respondent before lordship has been suffering from acute mental ailments. And he has been in constant medical treatment under 2 different psychiatrists of the city.
why not section 16 arbitrator nowadays arbitrators can also decide previously maybe fraud some question could have arisen
But-
but now it's not there
No, my lord, so far, my second point is the enforceability of the document itself.
why
My lord, because of the fact, your lordship will kindly have a look to the document.
why not enforceable
Well, it is not duly stamped, first of all, and secondly, unregistered. Hit by section 35 of the Stamp Act, as well as section 49 of the Indian Registration Act.
how do you deal with NN Global
My lord,
how do you deal with NN Global's case
yes, my lord, that I know, that I might know.
unfortunately I also know
My lord,
so NN Global has referred it to a larger bench but that bench has heard it pending I was educated yesterday on this actually regarding the larger bench so all these questions will be kept open to be decided by the arbitrator the order of the day is it has to be referred to arbitrator unless there is something gross
yes, yes, my lord, yes.
so I'll refer it section 11 there is
Then
why
my-
affidavits for this
Then your lordship kindly, the so far.
I'll keep the all the issues open sir. I'll have
my
to
lord,
I'll have
my-
to
And my lord, that about, my lord, this is the only hearth and home of the petitioner. There's no other shelter.
Mr. Raut, what is the valuation
1 crore 9 lakhs.
should I appoint an advocate of this court or a retired judge of the court?
I think my lord retired judge will be better.
Retired judge? Very well. Learned counsel for the petitioner seeks a reference to arbitration, comma, in view of no consensus having been arrived at between the parties regarding the arbitration. Full stop, next para. Affidavits in opposition and reply filed today be kept on record. Full stop. Learned counsel appearing for the respondent opposes the prayer under section 11 primarily on the ground that as per the respondent, comma, the petitioner had obtained the agreement in question. No, the petitioner had obtained. The agreement in question was executed by practice of fraud, comma, since the executant was a mental patient at the relevant juncture. Full stop. Next para. It is further argued that the enforceability of the agreement containing the arbitration clause is in dispute, comma, since the said agreement is not sufficiently stamped and is unregistered. Full stop. Next para. It has been well settled, comma, lastly in NN Global citation by the Supreme Court that the mere deficiency in stamp duty in the agreement, comma, even if there is any, comma, cannot render the arbitration itself nugatory. Full stop. Next para. In fact, comma, under the scope of section 16 of the Arbitration and Conciliation Act 1996, comma, it is for the arbitrator to decide all issues, including those of maintainability. Full stop. Next para. Insofar as fraud is concerned, comma, the same question pertains to primarily a dispute regarding facts and has also to be decided by the arbitrator, comma, as and when appointed. Full stop. Next para. The scope of this court under section 11 within bracket 6 capital A bracket closed of the 1996 Act is extremely limited, and the questions raised by the respondent cannot be gone into at this stage. Full stop. Next para. Hence, comma, since the dispute is otherwise arbitrable and falls within the FALLS, falls within the comes within the purview of the arbitration clause, comma, which is otherwise a valid clause, comma, the matter is decided by appointing an arbitrator. Full stop. Accordingly, AP 16 of 2023 is allowed, comma, thereby directing Justice Prosenjit Mondal, a former judge of this court, as the sole arbitrator to resolve the dispute between the parties, comma, subject to obtaining consent stroke declaration under section 12 of the Arbitration and Conciliation Act 1996. Thank you. What?
Item number 6.
But copy of the order will be on the website by this evening, I hope. Should be there. Yes.
Item number 6, Cementon.
My application.
The last question, my lord, you should the then Justice Chief Justice Director.
I'll tell you,
By
Lordship,
leaving
my lord,
him,
what is the matter about. My lord, this is
Because
in
of-
respect of an arbitration clause, my lord, with the railways. My lord, similarly, my lord, I'll my lord, take my lord, cite my lord, the Perkins judgment, which says my lord, section 12(5) my lord, will not be applicable so far as my lord, the retired employees or my lord, the employees of railways are concerned. And my lord, I shall also my lord, cite my lord, Honorable Justice Bhanumati's judgment, which says my lord, it is counterbalanced with regard to my lord, if there is 3 arbitrators. Now, the arbitration clause, my lord, contains of a sole arbitrator with respect to disputes which are within, my lord, 1 crore rupees. My lord, today, my lord, I am in default because, my lord, I have, my lord, brought, my lord, the agreement is there, but, my lord, it refers to the standard bid documents, or, my lord, rather, my lord, the GCC, the general conditions. That is with me, but the one which is with me, my lord, encompasses, my lord, 10 lakhs, which is, my lord, the previous one. Now it's been increased to 1 crore, my lord. This clause, my lord, is
So I'll-
increased to, my lord, 1 crore.
I'll require that also, my lord. But if he agrees, I won't require that.
I believe, my lord, I do not think, my lord,
Another bench,
I don't
you should kindly see that. Justice.
yes, I'll, my lord, place my, my lord, I have got it from, my lord, another brief of mine.
Recent
my
order
lord,
passed by Justice Forum.
Take instruction as to whether 11 names
Definitely
can be
also.
suggested. Acha. So you have suggested 11 names.
Yes,
You have suggested these 11 names. Justice Sharaf's order says, counsel appearing on the respondent is directed to take instruction as to whether 11 names can be suggested by the respondents, out of which one would be chosen by the petitioner. So have you chosen the 11 names and given to them?
That
This
may
is
be-
the order
that
you have placed.
That may be given, Malla. By the
Will be given, give it today.
No,
Give
Malad,
this
only,
11.
only difficulty is that Malad, there is a judgment of this honorable court also. Malad,
Oh,
in fact,
these,
two-
all
two
these
judgments.
11 will be also officers of the.
Yes, yes. Of course, yes. Of
Then you
course, yes.
should kindly, Malad.
Then what? Then
File for affidavit, Malad, kindly, Malad.
affidavit. Sorry, I'll refuse. Give the reasons. On what ground do you want to use affidavits? Tell me. If a question of law, argue. If a question of fact, won't
Some
entertain.
ground has
Section
been
11.
there, Malad. I'm not prepared because of Malad Eid, Malad. I should know that
Say that.
court may be.
Come back on Monday. Be prepared. And if you are absent on Monday, I'll pass orders ex parte.
Tuesday, Malad. Monday, I'm some Malad, engagement.
Very well. Tuesday. Tuesday. Please come back on Tuesday.
Very good. I'm grateful.
That's
Malad.
it.
I'll bring Malad the corrected Malad or the revised version of.
Yes. Yes. Learned counsel for the respondent hands over a printout of a server copy of an order of a coordinate bench passed in this matter, indicating that the respondents were directed to take instruction as to whether 11 names can be suggested by the respondents, out of which one would be chosen by the petitioner. Full stop. The second name, it was contemplated in the order, should be chosen by the respondents, and both these arbitrators shall be at liberty to choose the presiding arbitrator. Full stop. Next para. However, subsequently it transpires that the names sought to be suggested by the respondents are all officers of the Eastern Railway, which is one of the parties to the dispute. Full stop. Hence, as per the latest prevalent position of law, such officers are in all probability ineligible for becoming arbitrators under the ineligible for becoming arbitrators under the purview of the 1996 Act, including its schedules. Full stop. Next para. However, since learned counsel for the respondent further seeks an adjournment in the matter till Tuesday, the matter stands adjourned till April 25, 2023. Full stop. It is made clear that on the said date, in the event the respondents are not represented, the matter will be decided on merits in the absence of the respondents. I have not specified what will happen if the petitioner does not.
I am disputing regarding Malad 11 officers, Malad, because I have no instruction.
One more distinguishing feature is that Malad, in this case, Malad, the dispute claim amount is within Malad 1 crore rupees. So
Your client is more or less rich.
Yes.
Whether I should appoint an ex-judge of this court or an advocate or whatever.
Yes.
Malad, advocate of this honorable court.
Advocate, Malad.
Because the claim amount is Malad
Come back on
50
Tuesday.
lakhs.
Just remind me, come back on Tuesday.
Very well.
I'll deal with your points also. Whatever points you have to
Yes,
argue.
I have some point.
I'm grateful.
Obviously, you have some point. Eid. Oh, your resolution has also come. Eid.
Yes, Malad.
Grateful.
Item number 7,
7.
Brick Projects Private Limited.
May it please your lordship, appearing for the petition and item number 7. This is my section 11 application.
Yes.
My lord, I was supposed to file my reply by today, my lord. My lord, I'm seeking extension by a week for filing
A
reply,
week.
my lord.
Very well. Mr. Banerjee, I'm granting a week. Learned counsel for the petitioner seeks an extension to file affidavit in reply. So accordingly, such time is extended till April 28, 2023, when the matter shall next be listed under the same.
April 28. Lord, can it be Malad May 1st or May 3rd, Malad, if it's
Very
possible?
well.
Or
Tahle
4th,
28
5th,
na
4th,
kore,
4th.
reply time ta
4th,
extended till April 28. Push up the matter shall be listed under the same heading on May 4, May 4, 2023.
No.
Obliged.
Thursday.
Vacant.
Grateful.
Yes. Still vacant. Calendar. Yes.
Grateful, Malad.
Yeah, next matter.
Item number 8, Vishwajit Niyogi versus Sisti Enterprise and
Second
others.
call, first call passover.
Item number 9, Colliers International Property Services Private Limited.
Your Lordship, I'm for the petitioner. I'm led by Mr. Kumarjit Banerjee.
Start the
who's on
matter.
legs.
Start the matter.
Your Lordship would grant a short passover. He's on
He
legs.
will pass over in the first call.
Obliged, Your Lordship.
Item number 10, Vinith Gupta versus Mrs.
My lord, in
Giggles,
this
private
matter, I am
limited.
appearing on the behalf of the petitioner led by Mr. Trivedi, my lord. He has not come to court today, my lord. If it can be taken up on Tuesday, my lord.
Tuesday he'll not come to court on Monday also.
No, my lord, he will come, my lord, but there are PL matters in courtroom number 1.
Candid enough. I'll keep it on Tuesday. Very well.
Much
Very well.
obliged.
On the prayer of the petitioner, the matter is adjourned till 25th, April 25, 2020. Mr. Dheeraj Trivedi.
Yes, my lord.
Grateful, please.
Contempt matter, item number 11.
Yes.
The Calcutta Farmers Employees Cooperative Credit Society versus
Passed over in the
Rajan-
first call. Second call.
passed over matter. Item number 3.
My lord, in this matter, in item number 3, I've come to from the cause list. I am for the respondent, my lord, but let a copy be served. I will appear in the matter, my lord.
When should I take it up? Tuesday?
My lord.
Tuesday.
I shall serve.
What's your full name, please?
Shubhadeep Chakraborty,
You
my
will
lord.
be on record in this matter.
I will be, and my senior will be also there.
Whoever.
I will be there, my lord.
Mr. Shubhadeep Chakraborty, learned advocate, appears and submits that he has instruction to appear on behalf of the respondent in the matter and seeks a copy of the application under section 11 of the Arbitration and Conciliation Act 1996. Full stop.
I am
Lord,
my record I have given over.
Full stop. Very well. A copy thereof is handed over here and now by learned counsel appearing for the petitioner to Mr. Chakraborty to enable the respondent to contest the matter effectively. Full stop. The matter shall next be listed on April 25, 2023, Tuesday.
Grateful, my lord. Deeply obliged. My lord, my affidavit of service is not affirmed in case my lord permits.
Bring it on
On
Tuesday.
Tuesday, I come.
Now it will be affirmed easily.
It will be.
Yes. I've recorded that's why in the order.
Ma-
So it's easier for you to serve on it.
My lord. Much.
No, that. Item number 8.
None appears even on the second call. Adjourn till adjourn for the day. হ্যাঁ অর্ডার হবে এগুলো কারণ এটা অর্ডার করছি পরের দিন ডিসমিস করবো সেকেন্ড কলে কেউ আসছে না
আমরা 24 ছাড়া item number 9 passed over matter.
Your lordship, this is my section 11. Yesterday I
give me
had
half a
served
second
the-
Mr. এই
Very well.
ওটা কি বলে দেবো আরেকবার অর্ডারটা অর্ডার ফলো হয়নি none orders even in the second call none appears for the parties even in the second call even on the second call yes, sir. Accordingly let the matter stand adjourned for the day আমি বোধহয় অ্যাডজার্নমেন্ট দিচ্ছি ভেবে হয়তো খেয়াল করে হ্যাঁ ঠিক বেশ হ্যাঁ এটা কত নম্বরটা সরি মিস্টার ব্যানার্জি প্লিজ স্টার্ট
Yeah, nine, sir.
9 yes
This is my section 11, your lordship.
you're for the respondent
My lord, yes, my lord, I'm being led by Mr. Malik. My lord, I'm
which Mr. Malik
Mr. Utyo Malik. I'm just praying for a short passover.
are you opposing the arbitration
Section
this
9,
is the second call
Yes, my lord.
no passover in this call
Hmm.
Okay, very well. No, yesterday somebody else was appearing, so I got confused.
the situation can change again on Monday maybe
Certainly.
if I don't give time no but you are ready in the matter obviously not on the prayer of the respondent the matter is adjourned till 24th April. Plus but please come prepared on that date otherwise I'll take up the matter expertise
I'm deeply obliged, your lordship.
24th. Item number 11 contempt matter.
none appears for the parties even on the second call full stop it transpires from the order dated April 4 2023 that an appeal preferred by the alleged contemners against the parent order was pending delivery of judgment before the concerned division bench. Full stop next para since no further development has been reported to court, comma, let the matter stand adjourned and shall next be listed on May 8, 2023. 8th May. হয়ে গেল? Origin set? আচ্ছা, এটা কি? ও আচ্ছা, ঠিক আছে।
এটা 9
বোর্ডে একটা এডি দেখিয়ে দিতে বলুন তো জাস্ট এডি দেখিয়ে রেখে দিতে। আজ হচ্ছে 21 তারিখ। থ্যাংক ইউ। কালকে হ্যাঁ হ্যাঁ গেছিলেন। কিছু বলতে পারছি? আগে কি সিস্টেম ছিল জানেন? লিস্ট কয়েকজন অ্যাপ্লাই করেছে, অ্যাপ্লিকেশনের কোনো প্রভিশন তো চিফের স্ক্রিমে নেই। প্রভিশনটা কিন্তু আমাদের একটা ফর্মুলা, এটা আমাদের ফর্মুলা করতে জাস্টিস জজমেন্ট যেটা লিখে দিয়েছেন সেটা হচ্ছে যে এই যারা পিটিশন করেছে এরা হবে কিনা এটা ডিসাইড 5 মিনিট লাগবে, করে দেবো। জাস্টিস শরাফকে ডেকে একদিন বসে করে দেবো, ঠিক আছে? এদিক করে দেখা ওকে বলে দেবে অ্যাপেল সেট। আচ্ছা অরিত্র, যদি মোশনে কেউ না থাকে এই 6 পর্যন্ত কল করবো, অ্যাপ্লিকেশন পর্যন্ত, তারপর মোশন গুলো পসিবল করতে হবে সেকেন্ড কলে, তারপর যা করা করবো।
Appellate side, new motion, item 1.
Yes, Mr. Rai.
But I'm for the petition.
Served on the other side?
Yes, yes.
Yes, what is the matter?
Last day, Lord, they appeared, Lord.
Yes,
Report,
some
Lord,
question.
was filed, Lord. I today, Lord, file an exception.
No
to the
private
report.
respondent is there?
No private respondent.
Exception, what does
So
a...
Devjit Mukherjee, Lord, was
Yes, yes.
appearing.
His name is recorded. What is the exception and what is the report, Mr. Rai?
Lord, the report, Lord, this concerning, Lord.
Tell me the dispute once. You are seeking a new connection.
Yes, no, not new connection. Lord, what happened, Lord, in front of, Lord, my property. Lord, your lordship kindly comes to
company.
photograph once. Lord, annexed to the.
You want to open a gate there?
No, no, not that.
It's
Lord,
beside
this is
the
my
wall.
But I am for the distribution company. Last occasion, kindly see your lordship's order.
Why are you appearing virtually?
But I am suffering from a high fever, my lord.
Oh, all right. Very well.
Lord,
Yes, the report, they are filing an exception to the report. Have you...
My copy has not been served, my lord.
give a copy. Very well.
But kindly, I'm tendering apology because my lord, I could not, my lord, come to court physically.
Why are you not visible also, Mr. Mukherjee? You are in an embarrassing or compromising situation.
No, I'm opening, my lord. I'm opening, my lord.
I want to see you.
Yes, my lord.
Anyway, I'll see you next time. So I'll adjourn it till Monday. They'll give a copy.
My lord.
And
the clerk of Mr. Mukherjee.
Mr. Mukherjee, send your clerk to Mr. Kajol Rai.
Yes, my lord.
Anything else I have to convey? Tell me, I'll convey.
No, no.
Why not? I'm here for that.
My clerk is behind Mr. Rai, my lord.
Yes, yes, he has made his presence felt. An exception to the report filed by the WBSCTCL is submitted today by the petitioner, which is kept on record, full stop. A copy thereof be served today on the learned advocate for the WBSCTCL. The matter shall be listed on 24th April.
Grateful.
Item 2.
Appeal pending, still pending.
Some orders have been passed. Yesterday we mentioned that this has not been uploaded till now. Let it be.
My orders. Acha. When should I keep it? Tell me.
Monday. Other two matters have been kept on Monday.
Monday or Tuesday? Oh, Monday. Tuesday will be better, I think. On the prayer of Honored Counsel for the parties, the matter is adjourned till April 25th.
2 to 5, my lord. 2 to 5, same order.
2 to 5. Or 2 to 5 board দেখিয়ে দিতে হবে।
No, affidavit.
What is that?
No, affidavit of service.
Service. Affidavit of service. All the matters.
Yes, my lord. All the matters.
You have checked up 5 are there. You have checked up 4. The affidavit of service filed today be kept on record. Separate orders, same order. Separately record করবেন একসঙ্গে করতে হবে। Yes. মঙ্গলবার থাকবে না? হ্যাঁ। সবকটাই মঙ্গলবার থাকবে। তাহলে পাসওয়ার্ড কিছু রইলো না তো, ছেড়ে দাও। পাসওয়ার্ড তো কিছু নেই, সব হয়ে গেছে। কল করতে যাও।
Application. Item 6.
This is my application for restoration.
Within time?
No, my lord, I'm.
What is the
delayed by
delay?
4 months, my lord.
We have soft
It's a
copy.
changed matter. Yes, my lord, I've served the affidavit of services.
Good
here.
service.
My lord, I find only in respect of the last respondent, that is General Manager Sales and Marketing, my lord, it has
Eastern Coalfields itself has been served.
and only the respondent number 5, my lord.
Very good.
My lord, the-
What is the ground? I hope you have not abused the judge or something like that, which palpably it should be struck out or then I'll allow.
It's been set out in paragraphs 5 and.
You have checked up 4 months. Approximately.
So dismissed on 1st of April 2022 and my lord, this.
1st of April, it was dismissed for default. Order is a nullity. When did you apply?
This was filed, my lord, on 5th of November 2022. This is a change matter, my lord. There is a.
Despite service, none appears for the respondents. First up, it transpires that the service might not have been completed satisfactorily on the respondent number 5, comma, who is the general manager within bracket sales and marketing bracket closed, comma, Eastern Coalfields. First up, however, comma, in view of service having been duly effected on respondent number 4, comma, that is the Eastern Coalfields Limited itself, comma, it is deemed that the interest of all the respondents are properly represented. Full stop, next para. Since none appears for the respondents, comma, the matter is called on for hearing ex parte. Full stop. In view of sufficient reasons having been disclosed in the application for restoration for the delay in filing the same and for the absence of representation of the petitioner on the relevant date, comma, can 1 of 2022 is allowed, comma, thereby recalling the order dated April 1, 2022, passed in WPA 12858 of 2012 and restoring the said writ petition to its original file and number. First up, was there any interim order initially? Well,
One more thing, but I find that an affidavit in opposition has been filed by
to the restoration of
to the writ petition. My lord, I have to file my affidavit, but I was seeking only 10 days extension. my lord.
very well. হয়ে গেল, no order as to cost. তারপর একটা WPA নাম্বারের হেডিং দিয়ে আরেকটা অর্ডার হবে। Since the restoration application has been allowed, comma, the writ petition is taken up for hearing. Full stop, learned counsel for the petitioner seeks 10 days adjournment for filing his reply. Full stop. Accordingly, the time for filing affidavit in reply is extended till May 4, 2023. Full stop. The matter shall be listed on May 8, 2023. The matter na kore, the writ petition itself will be listed for hearing on May 8th.
নামটা স্যার old matter item 7
List শেষ হয়ে যাবে। None appears for the parties. Adjourn for the day. Several CV matters, no difficult.
item 8
Item 8, my lord, I am for the WBRC.
WBRC, yes. None appears for the petitioner or the DVC, although the WBRC is represented through counsel. Full stop. Let the matter stand adjourned and shall next be listed in the monthly list of May 2023. Monthly list of May, which is next Monday. Ritik Patnaik.
Item 9.
9, my lord, same.
Same order.
Same regulation under challenge.
Oh, that.
Regulation become infractuous now because new regulation.
I'll record your submission on the next date, Mr. Patnaik, and these have become infractuous basically, I suppose. So I'll record your submission on that. Please come prepared on that. Whatever regulation, give me the details. I'll record that and dismiss it as infractuous. Both the matters will be listed in the monthly list of May.
Grateful.
Same order, Madhu.
Item 10.
আগে অর্ডার আছে আমার ঘরে পুরনো আছে None appears for the parties. The matter shall be listed in the monthly list of May 2023. আজকে নট টুডে মনে হতো তাই আজকে নট টুডে মনে তাই কেন ও ঠিক বলেছো ঠিক
Item 11.
সেম অর্ডার এই অরিত্র আরো ওল্ড ম্যাটার আনিয়ে নিয়ে যেতে হবে ইওর মধ্যে ট্রে পাঠাও লিস্ট ফাঁকা হয়ে দেখতে খারাপ লাগে না
Item 12.
some other court for some other court same order monthly list of May.
Item 13.
Same. 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 Monthly list of May. Same.
None. Adjourned for the day.
Oh, thank God. Unless you prefer adjournment, Mr. Shen.
My lord. Lordship was saying same. I
Yes.
recollected, Lord, the days when I first joined. Justice Umesh Banerjee was taking residuary in courtroom number 11.
Yes.
And his lordship would say same order, same order, same order with regard to husking matters, submersible pumps. And I never could understand what the same order was.
Hope it was not dismissal order. Same order of dismissal.
Those matters have all disappeared. Submersible pump permission.
Some matters are there. They are there.
Yes, I'm thriving on those. Critical questions are being decided. Critical in the sense whether the zone is critical or semi-critical and requires a suite certificate. That is the criticality of them. Anyway,
Item 16.
16, yes.
My lord.
Mr. Jha, you are for the petition.
Well, I'm for the petitioner, my lord. My lord, I have given inspection of the original documents which were not legible
Yes,
to my learned friend, my lord. And for the perusal of your lordship, I'm just handing over this bunch. The first two documents are annexed there as annexure P5 and P6, the first two documents.
Yes.
The ones that those were illegible. And the police license, to them.
Please remind me the dispute
My
once,
lord.
Mr. Jha.
This dispute is regarding the occupation.
Yes.
The private respondents, they allege that the petitioners are not in occupation of that particular premises.
What a new connection.
My lord, for regarding
Right,
a new
right, right.
connection.
So
And the
occupation has been disputed.
My lord. And from the documents which I have stated, I've handed over or annexed even in my reply, from those documents, it is evident that the petitioners are in possession and occupation of the premises prior to 1968 even.
These
And
are the originals of those.
those documents, because the Bagh, Satish Chandra Bagh has been shown as the proprietor of R.N. Roy and Company.
Right. Very good. So this is the crux of the matter.
But this is the crux of the matter. My lord, on that particular issue regarding the occupation, my learned friend had placed a judgment before your lordship, which was
Had placed.
He had placed the judgment. My learned friend had placed
Also at the interim stage, Lord.
at interim stage. That was AIR 2006, Calcutta 73, wherein it was decided that trespassers are not entitled to supply of electricity and the
The
word
special bench judgment is there after
My
that.
lord.
Mr.
After that, there was a
Jain
judgment,
knows
my lord, of Santosh
that.
Jaiswal
Settled
versus
position is the
settled
last
position is
position.
there.
Yes.
Report in WBLR 2008 3 WR Calcutta 413.
I don't know. But for my lord's convenience, if your lordship prefers, Lord, instead of the
2006, sir.
Special bench.
আচ্ছা
দীপঙ্কর দত্ত
কোনটা রে?
এটা যেটা আমি দেখাচ্ছি
এটা অন্য কিছু।
অন্য judgment. All the issues and the judgments of this court has been dealt with in this particular judgment, my lord, and wherein the judgment cited by my learned friend was also dealt with. The issue that is dealt with in this matter, my lord, is that whether a licensee can be directed by the writ of mandamus to supply electricity to the prospective consumer thereof without he being in lawful occupation of the premises at which such supply is sought is a question which falls for determination before this court in this proceeding. My lord, will come to
the relevant clauses
my
are
lord.
in bold, in fact, in the
My
judgment
lord.
itself. So no difficulty.
The copy that I've handed over WBLR, my lord, that is paragraphed, but the one that I have taken a printout from the server, that is not paragraphed, your lordship. So I'll page number only. It's website.
Justice Otto's order. Justice Otto's order was considered by the special bench
My
also.
lord, it was
Other
it has
judgments were
been-
also.
it has been. So the word lawful with the amendment in 2003 Act, the word lawful is not there. It's the occupier is there. And it has been settled that a person who is in occupation of the premises, the license with the licensee, the licenser has to
Mr.
provide-
What documents are here? Just
two
indicate.
documents are there where Satish Chandra Bagh is the proprietor in 1968 itself.
Address same.
Address is same, 211 Acharya Prafulla Chandra Road. At that point of time, it was Upper Circular Road. In one of the documents, it's Upper Circular Road, my lord. So from the documents which I have handed over, your lordship, it's established that prior to 1968 itself, R.N. Roy and Company was a proprietorship under Satish Chandra Bagh. Your lordship will find Satish Chandra Bagh as the proprietor. Then your lordship, in the year 1981, in my reply, your lordship will come to page 11, your lordship. Page 11. This is a license which was issued by the under the West Bengal Baby Food Licensing Order 1966. From this document, it is evident. The document first time was issued in the year 1981. Your lordship will find the date at the bottom of the page. It's 25/9/1981, your lordship. 1981. And here, Messrs. R.N. Roy and Company, and the name of partners have been indicated: Shopon Kumar Bagh, Topon Kumar Bagh, Tulsidas Bagh, Gurudas Bagh, and all. And the address is 211 Acharya Prafulla Chandra Road. So the fact that R.N. Roy and Company had been converted from a proprietorship to partnership is also evident from this particular document, my lord. So the contention of my learned friend that the Roys were the original tenants and Bagh was a Kormochari in the year 2015, and they are interlopers or the persons who are not in occupation, is my lord, this submission cannot be held to be true in view of the documents that I have furnished to your lordship in my reply. So considering all these aspects, my lord, we are in occupation of that particular premises, and having made the application for a new connection, my lord, the CSC ought to effectuate inspection and install a new electric meter And the private respondents who have been obstructing that, they should not stand in our way because that is infringing upon the right to enjoy that particular property. Be that as it may, if there is a civil suit which is pending that has not been filed against me, that has been filed against the Roys, my lord. The Roys, from the documents which I have placed, prior to 1981, the Roys are nowhere in the picture of R.N. Roy and Company. So the suit which was filed in 2015-16.
What stand was taken by the CAC on the last occasion?
Well, they have no stand at all. They said that they could not effectuate inspection in view of the fact that the room was not made available to them, my lord.
Yes, Mr. Shen. You can take your time. I'm running in favor of time. No, please don't. I mean, you have other matters also, must.
Lord, two issues are there before your lordship. One, whether the petitioners are partners of the two persons alleged to be partners of the petitioner firm are in actual settled possession. Lord, your lordship sees the cause title to the writ petition, please, Lord. As your lordship would have observed, the writ petition has not relied upon the writ petition at all today, and only on the affidavit in reply. Lord, if your lordship kindly takes the writ petition, and Lord, please seize the cause title.
Yes.
It is R.N. Roy and Brothers, represented by its partner, namely Tulsi Bagh, son of such and such. Now, Lord, if your lordship is pleased to take this cause title along with paragraph 2, your lordship will find the averment is that the petitioner is one of the partners of the partnership firm, namely R.N. Roy and Brothers, which has the petitioner as well as one Krishanu Bagh as partners. So, Lord, the case being made out by Tulsi Bagh and Krishanu Bagh is that they are partners of R.N. Roy and Brothers, and they are entitled to electric connection, a new electric connection. Now, Lord, if it's an application for a new electric connection, two things come into operation immediately. One is section 43, where my learned friend must show that today he is in settled possession. And secondly, if it's a new electric connection where the works are to be carried out for the first time, then he must also satisfy the works of licensees rules 2006.
Why at this stage, Mr. Shen? Because works of licenses rules at this stage, why?
Lord, if it is for a new electric connection.
Yes, those will be followed.
If it's a new electric connection where the works are being carried out, the laying of the electric line is to be done. That is for the electricity CSC to say.
That they'll hold an inspection, and
that is for them to say whether there is an electric line there or not. If not, then they require two things. One is permission from either owner or occupier, and an objection from either of the two will also put it into disarray. Because if there is an objection from either or, then it's either district magistrate or the police commissioner.
You are the owner of the premises. What are
Lord, I am one of the executors of the estate of the person who was one of the owners. I am the respondent number 3 in the writ petition. Application for a grant of probate is pending in the Learned City Civil Court at Calcutta. Now, Lord, kindly see, may I, before I come to the facts, take your lordship to the judgment of the special bench, because that will be of some significance. Lord, I'll ignore the first few paragraphs because your lordship has seen that many times. Lord. Your lordship is kind enough to take the SEC online version. It will be convenient for me, Lord. I need not take the points which were for consideration. Your lordship is aware of that, Lord.
Not necessary.
Please come, Lord, directly to page 22.
Yes.
Lord, here the broad question has been framed. The broad question before us is whether a person who is an encroacher upon land belonging to another without any right or permission conferred by such owner can be treated as an occupier within the meaning of section 43 of the Act. In the Electricity Act 2003, there is no definition of the word occupier, but the works of licensee rules 2006 framed under the aforesaid act came into force in the year 2006. And according to the definition of occupier as provided in Rule 2B, unless the context otherwise requires, the occupier of any building or land means a person in lawful occupation of that building or land. According to Subrule 2, all other words or expressions used in the rules and not defined in these rules should have the meanings respectively assigned to them in the act. Then please come to the next page. Lord, the larger paragraph towards the middle of the page.
Yes.
In our opinion, middle of that paragraph, it says, in our opinion, by the word lawful occupier introduced in the rules, the legislature intended to mean the actual person in settled possession of the property, and the licensee is required to take the permission of such a person in settled possession of the property if the property is not in possession of the owner. Whether the occupation of a person on a property is lawful or not can only be decided by a competent forum prescribed by law. It was never the intention of the legislature in defining the word occupier as lawful occupier to ask the licensee to take permission before undertaking any work from the person in occupation, if such person is not the owner, after being satisfied that such occupier has been declared as lawful occupier by the competent forum prescribed by law. So, although I am at one stage before this comes into operation, this is one aspect of the matter, which CSC will have to first cross before they actually go for inspection. Today, on the last occasion, CSC came and said, we have no submissions to make. We went to take inspection. We could not open the door.
Mr. Shen, in the opposition, what is your case? They were never in possession. Bagh was never in possession.
In the affidavit in opposition, my case is that the partnership firm of R.N. Roy and Brothers was a tenant under the landlords. R.N. Roy and Brothers was a partnership comprising of 4 persons. Eviction suit filed by the landlord against R.N. Roy and Brothers. There, in the eviction notice, ground taken of having left the premises. In 2015, it appears the electricity was disconnected. We also filed a suit for declaration injunction. We got an order of ad interim injunction, which records that electricity has to disconnected. Now, R.N. Roy and Brothers has not been able to show anything before your lordship that this partnership firm has continued in occupation. The persons who are coming up before your lordship are showing a partnership deed of September 2022 to allege that they are now R.N. Roy and Brothers. Now, if the original firm of R.N. Roy and Brothers has transferred their right, title and interest in favor of the new persons, there has to be some document. I'll show your lordship the deed, the partnership deed which has been annexed. It says it's a new partnership firm which is now being constituted to start the business.
How far can we go into this this matter?
In this matter, because it is necessary, because your lordship will first have to, if at all your lordship is minded to pass any order in favor of the petitioner, that
settled occupation.
Yes,
that has to be.
Because if I can demonstrate, lordship, that these persons, Tulsi Bagh and the other gentleman, Krishanu Bagh, are not in settled possession, and they are interlopers, third parties, busybodies who are claiming to be the partnership firm, then they are not entitled.
So the documents they're producing is one, the recent deed of partnership. You say it does not show any devolution from that previous partnership firm. And the second thing they're showing is a bunch of documents regarding previous position as sole proprietor
in
of
1968, etc.
68, that range. So there is nothing current to show the devolution, how it came to be attributed to them. Very good.
Now, if your lordship kindly turns to page number 24.
Yes.
Lord, I'll ignore the first portion. And if your lordship is pleased to take paragraph 9.
Yes.
In the middle of the page. It is a settled possession or effective possession of a person without title, which would entitle him to protect his possession even as against the true owner. The concept of settled possession and the right of the possessor to protect his possession against the owner has come up to be settled by a catena of decisions. Lord Munshi Ram is referred and is cited. In Munshi Ram, it was held that no one, including the true owner, has the right to dispossess the trespasser by force if the trespasser is in settled possession of the land, and in such a case, unless he is evicted in the due course of law, he is entitled to defend his possession even against the rightful owner. But mere stray or even intermittent acts of trespass do not give such a right against the true owner. The possession which a trespasser is entitled to defend against the right owner must be settled possession extending over a sufficiently long period of time and acquiesced to by the true owner. A casual act of possession would not have the effect of interrupting the possession of the rightful owner. The rightful owner may re-enter and reinstate himself provided he does not use more force than is necessary. Such entry will be viewed only as resistance to an intrusion upon his possession which has never been lost. A stray act of trespass or a possession which has not matured into settled possession can be obstructed or removed by the true owner even by using necessary force. In Puran Singh, the court clarified that it is difficult to lay down any hard and fast rule as to when the possession of a trespasser can mature into settled possession. The settled possession must be 1, effective, 2, undisturbed, 3, to the knowledge of the owner, or without any attempt and concealment by the trespasser. This is almost like the principles of adverse possession. The phrase settled possession does not carry any special charm of magic in it, nor is it a ritualistic formula which can be confined in a straitjacket. An occupation of the property by a person as an agent or a servant acting at the instance of the owner will not amount to actual physical possession. Court has laid down following tests. Now, please take 1 or 2 of the 4 tests. 1, the trespasser must be in actual physical possession of the property over a sufficiently long period. Today, my lord, the only document which is being shown to your lordship, Lord, are documents which relate either to 1968 in the name of some other person, Shutish Chandra Bagh, and those are relatable to really permissions to carry on business under Food Licensing Act, Police Act, not to carry on business as a sarai, etc. And Lord, a partnership deed, which has been annexed in the affidavit in reply. Now, Lord, in the petition, the only document which was shown to be of more or less recent times was a certificate of enlistment. I'll take your lordship to it. A certificate of enlistment is the only document in the writ petition. That was of September 2022, 9 September 2022. The certificate of enlistment contained the names of these 2 gentlemen. So, Lord, immediately on coming to learn of this, Lord, we filed 2 things before the corporation. One is a written objection and an application to revoke the certificate of enlistment. We've annexed that in our affidavit in opposition. We've received no reply to that. So, Lord, we filed a right to information application, an RTI application. This was after the affidavit in opposition was filed. In response to the right to information application that we filed, the corporation called us because we asked for documents, called us and made over to us 2 documents, saying that it is on the basis of these 2 documents that we issued the certificate of enlistment or the trade license. One document is a rent receipt issued by Suhash Chandra Shur, whose estate we represent. Suhash Shur has died a decade before the rent receipt was issued. Rent receipt is sometime of 2022, and he's died in 2013, I'm sorry. The death certificate is part of our affidavit in opposition, Lord, and Lord, the other document apart from this death certificate is this partnership deed.
We have annexed those also in the opposition.
No, this way we did after the affidavit was filed, which is why we filed a supplementary affidavit, which I said would have some bearing upon the matter, because this is the only document on which the petitioner can rely upon in the writ petition, the certificate of enlistment of September 2003 of 2023. Now, nothing that he is today in actual possession by way of settled possession is there before your lordship. Neither is there anything there that he has been there over a sufficient period of time, A, effectively, B, undisturbed, since we have instituted proceedings for eviction, 3, to the knowledge of the owner, because I'll show your lordship that to the knowledge of the owner.
Eviction proceeding was instituted when? After the writ?
No, 2015. But not against us.
Naturally, against R.N. Roy and Brothers,
Acha, very
against R.N. Roy and Brothers, the cause title says R.N. Roy and Brothers,
Right.
represented by its partners, the partners are named. And the suit is now fixed for ex parte hearing.
Right.
Now, so it must be to the knowledge of the owner. Your Lordship has seen point number 3 at the bottom of page 24. The first is effective, second is undisturbed, 3 is to the knowledge of the owner. At no point of time was it ever brought to the knowledge of the owners that these two gentlemen, Tulshi and Krishanu, were there as partners of the firm. Without any attempt and concealment by the trespasser. You know, that's also repeated as point number 2 in bold in the next page. That the trespasser must, to the knowledge either expressed or implied of the owner, or without any attempt at concealment by the trespasser, and which contains an element of animus possidendi. The nature of possession of the trespasser would, however, be a matter to be decided on the facts and circumstances of each case. The next two are really not relevant for our purpose. Proceeding on this basis of settled possession, please first take note what they have disclosed in the writ petition and what we have said in response to that, and then I'll come to these documents. Your Lordship takes the writ petition. I've shown your Lordship the cause title. I've taken your Lordship to paragraphs 2 and 3. 2 which says who are the partners, Tulshi Bagh and Krishanu Bagh, and 3 says that the petitioner's firm is a tenant. Lord, please see this in conjunction with paragraph 3, the next page. Lord, may I just place this paragraph? The petitioner's firm is a tenant in respect of one shop room under respond number 3, who is the present landlord of premises number such and such as per information of the petitioner, since it was the respond number 3 who had lastly issued rent receipt in favor of the petitioner from last 7 years. Until now, the petitioner's firm is under the occupation of the premises. So, Mulad, the case made out, and Mulad, please see the annexures, photocopy of rent receipt of March 2015 and rent receipt of March 1418. 1418 is 2012. So, Mulad, the case made out in the writ petition is that the partnership firm of R.N. Roy and Brothers, represented by Tulshi Bagh and Krishanu Bagh, have been tenants since at least 2012, which is a decade. And they have rent receipts at least up to March 2015. Now, Lord, please see these two documents which are annexed to the writ petition, which is page 13 and 14. Lord, page 13, Lord, if it is legible to your Lordship,
yes,
your Lordship will find that it's a rent receipt issued in the name of Ram Nirikhon Roy and Brothers, which is admittedly the name of the partnership firm, which was our tenant.
Right.
And the names of these two gentlemen do not appear there.
You have also produced the original of this document.
This document I have not produced.
Right. Nita Shur is the respondent 3.
She's respondent. And Lord, please see the next document, which is issued by the predecessor, the testator, which is of 1418, 2012, also in the name of Ram Nirikhon Roy and Brothers. Lordship has seen page 14, Ram Nirikhon Roy and Brothers.
Yes.
R.N. Roy and Brothers, essentially.
I've seen page 13, page 14, and your signature in your opposition.
My signature?
Nita Shur.
Oh. Yes.
These 3 things. Yes.
Yes. Huh? Now, Lord, before I proceed further, Lord, please take the affidavit in reply.
Right.
And I'll come back to the petition, Lord. Look, this affidavit in reply was one of the documents which we had annexed in our supplementary affidavit, which we had made over day before yesterday. Lord, please, the affidavit in reply is at page 15 of the partnership details is at page 15 of the affidavit in reply. Lord, please take the recital at the next page. This is of 31st of August, 2022. Your Lordship has seen the date 31st August 2022.
Yes.
And Lord, please see the recital. Whereas the party to the first part and second part are desirous of starting partnership business of such and such, and being desirous of the same have agreed to put the terms and conditions of the partnership into writing. Then Lord, please see the next recital. And whereas the parties to this agreement have decided to carry on business amongst themselves. 3-4 lines below, your Lordship will find under the name and style of R.N. Roy and Brothers as partners with effect from 31st August 2022. Lord, please see the clause number 1. The name of the firm shall be R.N. Roy and Brothers. Not very important. Lord, please see clause 6, capital.
Yes.
That the capital of the firm shall be rupees 1 lakh contributed by each of the parties to this agreement equally, and such sum or sums of money as shall for that purpose appear in the books of accounts of the firm to the credit of each partner hereto. So, Lord, 2 or 3 things, Lord, your Lordship will immediately notice. Lord, this is a new partnership firm which is intended to be formed on this day itself, 31st of August 2022. Therefore, certainly this partnership firm could not have been the partnership firm which had paid the rents in 2015 or even in 2012. Because the business and the firm is intended to be started from this date. Now, secondly, your Lordship will notice that in the partnership deed, there is no recital at all that an earlier partnership firm was in existence. That earlier partnership firm is being reconstituted either by way of retirement or death or resignation of the earlier partners. So, Lord, that partnership firm, which is our tenant, which paid rent, which we accepted and whom we admit to be our tenant, of course, now a tenant at sufferance.
Yes.
Lord, that is not this firm. This is an interloper using the same name and trying to gain access into the property under the guise of obtaining an electric line. Now, the third thing a Lordship will notice that if there was an earlier firm and that earlier firm stands not transferred with its assets and properties, the capital which had accrued to the account of the firm would be the starting capital of this firm. Even if I say that recitals have been missed out, the capital could not be the capital as the 2 partners have brought in. So, Lord, by no dint can it be contended that this deed of partnership represents the partnership firm which was our tenant and which is our tenant at today, subject to the decree which may be passed by the court. Now, Lord, if your Lordship please comes back to the writ petition. One thing your Lordship will notice that in the writ petition, only 2 documents have been annexed by way of rent. In the affidavit in reply, it has not been argued that any further rent receipts have been disclosed. So, in fact, the last rent paid was of March 2015 by another firm by the same name. It is just like, my Lord, Mr. Jha and I constitute a partnership firm. We take a tenancy. We've left in 2015. There's a suit instituted against us. Electricity has stood disconnected. Now, my junior and my friend, they form another firm of their own using the same name. And now, as interlopers, they're trying to get electricity connection here.
Yes.
Number, if this is an application for new electric connection, which is not the avowed case in the writ petition, which your Lordship will find in paragraphs 5 and 11 of the writ petition. Lord, please see paragraph 5.
Yes.
The petitioner states that the petitioner submitted an application for obtaining new electric connection with annexure such and such on 10th of October 2022. And the prayers are for grant of new electric connection. Lord, this is also, Lord, your Lordship will find in paragraph 11 of the writ petition. The same pleading, deprived of new electric connection. Now, Lord, if your Lordship is pleased to come to the affidavit in reply. Lord, please see, Lord, page 13.
Yes.
Lord, in our suit, Lord, which I'll take your lordship to, we had made an averment that electric connection has stood disconnected. And that has been recorded by the learned court below in the application under Order 39, Rule 1 and 2. In their affidavit in reply, they say that electricity has been restored. And a lot that document is at page 13.
No, it has. We have not said. We have paid, but the restoration was not made due to unavailability of the room.
Very well. It has been paid. Makes no difference to my argument. I may have understood the pleading wrongly or the document wrongly, but it shows payment of electricity by R.N. Roy and Brothers on 31st August 2015. If that is so, if electric line has been disconnected once, full payment has been made, and my learned friend says line has not been restored, then it is not an application for a new connection at all.
No, Mr. Shen, their regulations say that after 180 days of the term,
They have to apply. On pleading all this.
For a new application.
There's a form. Because the 43 says that appropriate form. It cannot be not simplicity and innocuous application for new connection.
Very good.
Now, Lord, if I may come to the other document in the writ petition. Which was the only document which, Lord, I troubled your lordship on the ad interim day. Lord, this is the certificate of enlistment, which is annexure P1 at page 12.
Page 12, yes.
Your lordship will find the date at the top is 9 September 2022. And your lordship will find the financial years 2022-2023 and 4 lines below that. R.N. Roy and Brothers, name of certificate enlistment holder, Tulshi Bagh and Krishanu Bagh. And the address is the same. Now, Lord, if your lordship is pleased to take the supplementary affidavit, Lord, this is why, Lord, this becomes relevant to show, Lord, the dispute with regard to this document. Because in fact, this is the only document showing the present status, if at all your lordship relies on this. Lord, please see, Lord, the second page of the supplementary application affidavit. Lord, please take paragraph 3. On 24 January 2023, a RTI application was made before the Kolkata Municipal Corporation seeking the documents on the basis of which the certificate of enlistment was issued. Subsequently, the municipal authorities called me for a hearing and handed over a rent receipt issued by late Subhash Chandra Sood dated 2nd August 2022, along with the deed of partnership dated 31st August 2022. It is specifically mentioned here that late Subhash Chandra Sood passed away on 9th December 2013. It is evident that the petitioners herein forged the rent receipt in order to get the certificate of enlistment. Paragraph 4. Thereafter, a complaint has been lodged on 8 April 2023 before the Shampugul police station against the petitioners in regard to forgery of the receipt, showing the forged signature of late Subhash Chandra Sood dated 2nd August 2022. Now, the rent receipt of Subhash Chandra Sood is annexed to the supplementary affidavit. This is the document which was made over to us by the corporation. My learned friend does not say that this was not filed on his client's behalf. The supplementary affidavit is with him. It's not 2nd of August 2022. Your lordship will find the death certificate of Subhash Sood at page 74 of the affidavit in opposition.
Yes.
Your lordship will see the date is 9th December 2013.
Right.
Lordship, please see the stamp at the bottom of page 6. This is the document I obtained from the corporation. Page 6 of the supplementary affidavit.
Yes.
Now, there's an endorsement by the corporation that this was a certificate provided under the RTI Act. Provided to me under the on my application.
Yes. Right.
Now, the other document given. ঠিক আছে, এটা তো ওটাই annex করছি। Now, the second document is the deed of partnership, which was also given to me by the corporation, which is annexed in their affidavit in opposition, which I have made submissions on. এটা না রে, repetition নেই। আমি পাইনি তোদের affidavit in reply তে আছে। যাই হোক, আছে affidavit in reply তে আছে। Now, Lord, please take note the case made out by me in my affidavit in opposition. Lord, please take page 15, which is a suit filed by me. What has happened in the suit, and Lord, the stages of the suit are really not material because Lord, suit has not yet crystallized into a decree. But Lord, what is not the stand taken by me vis-a-vis Lord R.N. Roy and Brothers, and who R.N. Roy and Brothers is? Lord, please take page 15. This is Lord the Lord
Covering page.
the certified copy of the plate. Page 17, your Lordship will find that the case was fixed for ex parte hearing. 23rd February 2023 for ex parte hearing. But important is the cause title, which your Lordship will find at page 24.
Yes.
The plaintiff number 1 is the respondent number 3 here, Nita Shur. Not please see the defendants. Ram Nirikhon Roy and Brothers, represented by its partners, namely Ram Nirikhon Roy, Janok Deo Roy, Raghav Roy, Ambika Prasad Roy, and Shambhu Prasad Roy.
That's your plaint.
Naturally, yes, that's my plaint. And it is R.N. Roy and Brothers.
Bypassing them, you could have filed this suit
Exactly.
in the name of someone else.
Well,
I mean, who had the original partner? That could have been.
in place of
does
Ram,
not clinch anything in your favor.
except not because Lord, as I showed your Lordship, Lord, the judgment as to what is meant by a person in settled possession. One of the issues is it must be to my knowledge.
Yes. Yes.
And but till date, nothing has been shown to your Lordship that they were demonstrably, to my knowledge, in possession. So if Ram Nirikhon Roy and Brothers was there,
what is your stand on your signature on that rent receipt? It was issued to the
Ram
previous
Nirikhon Roy and Brothers,
Ram
R.N. Roy and Brothers, yes. These are all part of the plain documents also. They're all documents before the trial court. But this suit was instituted by a notice of ejectment. Your Lordship says, this is my case. Rightly, it is my case. My case is that R.N. Roy and Brothers was represented by 4 persons. Now, this can happen. R.N. Roy and Brothers may exist as a proprietorship firm, and I may have disguised it to show it as a partnership firm. Or it may have been a partnership firm, which later has transferred its assets, or they may have resigned or died or retired, and they may have taken over the partnership. In either case, but like
no reflection in their details.
No reflection in their deed, and nothing to show that they had brought it to my notice.
Yes, your notice.
That is imperative, Lord, for showing that they are in settled possession. Lord, like Lord, hostile possession and under the adverse possession.
A little on a lower footing, but almost
one pedestal below, but at least up the same ladder.
Yes.
They must bring it to my notice. My knowledge is important. Now, Lord, if your Lordship is pleased to see the affidavit in reply, which I, of course, did not have a chance to deal with, but the documents which were shown to your Lordship. Look, the pleadings really don't take my learned friends anywhere, because all they say was that R.N. Roy was originally a proprietorship of Satish Chandra Bagh, who was the tenant. If then there is from Satish Chandra Bagh, it has come to my learned friends and they have changed the character into that of a partnership. This gives me an additional ground for ejectment. That is different, but nothing to show that they have brought it to my notice ever. Now, Lord, please see the documents. The first document, Lord, if your Lordship sees the first document at page 9, This is a paper in connection with some appeal case, not what I can make out from the document with me. It is hardly legible. It's completely black. It relates to some appeal related documents before the
This is Commissioner of Commercial Taxes.
against R.N. Roy and Company. Proprietor Satish Chandra Bagh, 3rd July 1968.
Yes.
Now, my lord, a proprietor in possession may have, it now appears, could be, I do not know, because we are before your lordship in the constitutional court, not before the civil court.
Yes. Now you remember.
Huh?
Now you remember. When their documents come, Mr. Sen.
Now these documents have come and these will.
When their documents come, you are citing those, then you have remembered this, that you are before a constitutional meeting.
No.
You are arguing on your suit and the
No,
merits
I'm
of
not
the
arguing on my suit. I'm trying to show what
The
was to
question
my
is, Mr.
knowledge.
Sen, shall we go to that extent? I mean, that's the debate. You are saying prima facie they have to show something regarding it was within your knowledge. One. Secondly, that like adverse person, I mean, but suppose somebody shows that by hook or by crook, they were proprietors of some firm there, some other firm, suppose, in 1968.
Who was there? Not these two gentlemen.
Bagh was there as
There's
proprietor.
Satish Chandra Bagh. These are here. They are not Satish Chandra Bagh.
81's document page.
I'll come to the documents one by one.
Achha.
Page
This
11 is.
page 9 and page 10 are in the name of Satish Chandra. 9, 10 I can't make out. Must be Satish Chandra Bagh. The paper document is lordship.
11.
When I read it, Satish Chandra Bagh. These are some tax related papers in relation to Satish Chandra Bagh.
Yes.
Satish Chandra Bagh, not of a partnership firm. Satish Chandra Bagh claiming himself to be a proprietorship.
Yes.
Now, when Satish Chandra Bagh has problems with regard to his commercial tax, commercial tax.
Commercial tax.
It's commercial.
Lord, he may be an SSE individually also.
Yes.
It does not show that Satish Chandra Bagh individually was a tenant of this premises.
Mr. Saran and Company, proprietor Satish Chandra Bagh. That is there.
And address is
In that
211 Acharya Praful Chandra.
Lord, Satish Chandra Bagh as proprietor of R.N. Bagh and Company.
R.N. Roy.
R.N. Roy, does it say?
Yes.
Lord, and it say and brothers.
No,
And
company.
company.
R.N. Roy and Company.
Company.
And Lord, please see the partnership deed.
Yeah, reconstituted.
Please see the partnership deed.
And Roy and Brothers.
Yes.
Two different firms.
Yes.
R.N. Roy and Brothers.
The
Congress excited with this.
What is the age of Tulsi Bagh? Let me check up whether he could be there in 1968. Satish Bagh was there. He's not his son, Satish's son.
Now, Lord, Satish saying that he's the proprietor of R.N. Roy, I presume it's company. I can't read it.
Some Bagh was there as proprietor of that.
Of Bagh. And he's
Did not
and he has filed some proceedings before
Yes.
in relation to his tax issues. From this, it does not appear that he was a tenant of this premises in this name, either as proprietor or as a partnership firm. Nothing stops him from me filing my income tax returns in the name of Shamrat Sen and Company and having another partnership firm with 4-5 other people in the name of partnership firm.
They could not have anticipated this dispute at that point of time. Too many presumptions have to be then made.
Not too many presumptions for your lordship to come to a finding that they are in settled possession.
Prior
In the
to
Constitutional Court.
something has been produced. Many things have been produced.
Not primary.
Yes, you are disputing that. There is a valid chain. If it was beyond reasonable doubt, as in a criminal case, Mr. Sen, then the chain of events, the links might not have been established beyond doubt. Definitely. Because there was some other partnership firm.
Not today in 2023.
Yes.
What is the document, if I may ask myself?
One is certificate of enlistment, the merits
That is
of which I have to go into on the basis of your supplementary affidavit.
Yes.
But there's a presumption of correctness.
No, there is no presumption of correctness. I'll show the judgment with regard to that.
Achha. Evidence Act does not apply, section 140.
Insofar as certificate of enlistment is concerned, the court say, including, in fact, I relied on the judgment of Justice Jointo Biswas, not for the proposition that an unlawful person in unlawful possession is not entirely electricity. That was the law then. The law in
Certificate of
2011
enlistment
has changed.
does not
He's
get
not to
any-
be relied on. He's not to be relied on as not a document to show that he is in possession.
Very good.
Now, my lord, today in 2023, there is only the certificate of enlistment and nothing else.
Deed, if you say.
No,
deed
my lord,
mentions
deed
that-
does not show that he is carrying on business here. I and my learned friend,
That address, partnership deed.
look, today I, Samrat
It's a
Sen and
registered
Amrita Paja.
firm.
No. I and Amrita Paja can have a deed of partnership showing that we are carrying on business at your lordship's residence.
Very bad example.
No, this is such a bad case, Lord.
Not at all.
Very
Or as
yes.
I see.
Because there's nothing to show the authenticity of this document. It's an internal document between the two of us.
That will be a
And taking
nullity for other in other respects.
And
Because I
taking-
don't have any house in mind.
And
I don't have any house. Father's house and pigeon house.
in that case, it's a very bad example.
Anyway, Mr.
But-
So yes, I understand what you're saying. Yes.
Fact of the matter is, it's not a registered partnership firm. Even registration would not make any difference, and nothing to show that such a firm exists. And this firm was set up in August 2022.
Your case is very arguable, Mr. Sen. I'm being very frank. Very arguable. But my dilemma is how, subject to hearing Mr. Jha,
Lord,
how far we can go into that fact-finding exercise.
since I'm showing your lordship disputed questions of fact on the issue whether he is in settled possession, my
Very good,
respectful
very good.
submission is today your lordship is
That
would
cannot
not be in a position to come to a finding that he is in settled
All
possession,
right.
which is a prerequisite
Very
for
good.
your lordship to interfere.
Unless they get somewhere they get a sanction, declaration of court or whatever.
Something. Now, Lord, please see the other document. I've shown your lordship pages 9 and 10. Now, Lord, please come to page 11.
Mr. Sen, I'll come back in
My-
10
my-
minutes.
Lord, in my respectful submission, the foundational fact, which is a precondition before my learned friend can call upon your lordship to Lord direct CAC to Lord give new connection, is that he must be able to demonstrate that he is in settled possession. Before that, Lord, unless he shows that, and it is not prima facie, because this is the only stage and the final stage. There is no other avenue where Lord he has to further demonstrate or I can show the contrary. So he has to today conclusively demonstrate your lordship that he is in settled possession. One, Lord, I have demonstrated that there is no knowledge. Secondly, Lord, from the special bench's judgment, your lordship will have seen the expression that Lord, a casual act or a intermittent act, or Lord, even Lord, a sporadic Lord document, which is Lord, which has come for a stray act, will not do. These are some stray documents which have been shown to your lordship, which I'm even apart from although they are stray, I'm trying to disprove of the fact on the basis of these documents that they don't demonstrate that he is today in Lord possession, settled possession. Now, Lord, please come to the document at page 11 of the affidavit in reply. Yes. This is Lord, a document under the West Bengal Baby Food Licensing Order. Now, your lordship will find the date here on the middle of the page on the left hand side, renewed for 1986. Yes. License will expire on 31st December 1986. Top right hand corner, there's a stamp I find renewed for 1992 and up to 31st December 1992. Not subject to correction by my learned friend from whatever I can make out from this document, which is darkened in my copy. These are the two battery limits. I find that there's an endorsement of 88. There's some endorsement.
93 is the latest probably.
What are you? 93. My learned friend says 93.
93 is the latest date. I mean, year. Yes.
That's 20 years. 90. No, 30 years. 30
Yes,
years.
30 years.
92. This I remember, if your lordship permits you, one more digression. I remember that my enrollment was on 30th November 1992, but I did not get the letter from the Bar Council.
As usual.
Lord, I got the letter on 4th of December, and 6th of December was the Babri Masjid demolition. So everything closed down.
Ill luck.
That was a Friday, and then Sunday was the Babri Masjid demolition. So everything closed down. So 30 years, it just made me recollect that I've also crossed so many years.
Exactly.
One more.
Exactly. That is one of the considerations which have to come in.
So document 30 years back.
Yes.
And if your lordship permits me one more digression, but since your lordship said that lordship has some time, lordship remembers a serial called Ye Jo Hai Zindagi on television.
Yes.
There was
a serial.
One character, I think he was to play by Satish Shah.
Satish Shah. Yes.
They have 30 years experience.
Yes, 30 years experience. Satish Shah was splendid in that.
20 years.
Oh, whatever number of years, but he was splendid there. Shafi Inamdar was also there. Swarup Sampath was there. These three I remember.
Yes. So those are what of our times, because
yes, 30 years from that I am also recollecting these things.
And we have nostalgic feelings about that even till date.
Now there are so many channels, so many programs that one does not remember anything. It's just a matter of moment, but those we remember.
The Bengali serials, if you have the privilege to watch one of those, Mr. Shen, everybody is in formals always. I mean, formals or ceremonial dresses in their homes. And advocates probably go to sleep with their band on. Ridiculous. Previous old Bengali movies were better depicting courts.
They had
Vikas Rai and all. Yes, those were there. Anyway.
So, look, this is of vintage.
This is of vintage, yes.
And even there, your lordship find in the middle of the page, the name is of R.N. Roy and Company, not the present partnership firm R.N. Roy and Brothers. The partnership firm who is the writ petitioner is R.N. Roy and Brothers.
Oh, yes.
The partnership document which has been annexed is of R.N. Roy and Brothers. The partnership deed which has been annexed at page 15. The name of the firm at page 17 is R.N. Roy and Brothers.
Right. Brothers.
And here the partners of R.N. Roy and Company appear to be, apart from the Shopon Roy, Shopon Bagh, Topon Bagh, Tulsi Bagh, Gurudash Bagh, which is why the number of tigers have increased in the last census.
That's a very good one, Mr. Sen.
Lord, please turn the page over, Lord.
Yes.
This is of 9th of March 2016. 7 years.
Yes.
7 years, Lord, is the time under, Lord, I think 107 of the Evidence Act when there's presumption of death.
They've taken so much trouble, Mr. Sen. We should appreciate that. They've collected these documents, but your client is also very, very alert and went to the corporation, brought this documents.
Lord, they're trying to protect their ancestral property.
Obviously.
Now, this is 9th of March 2016, and it's in the name of only Krishanu Bagh, not in the name of R.N. Roy and Brothers or R.N. Roy and Company or Shutish Chandra Bagh. So, Lord, different documents. Then, Lord, the next document is the payment of CSC bill, which I say, Lord, goes against them. And in any case, it is in the name of R.N. Roy, does not disclose anything else. This shows payment was made after disconnection. If payment was made after disconnection, this should have been disclosed and they should have been called upon to reconnect, not application for new connection. At that point of time, they should have asked for reconnection. Now, Lord, so far as the earlier documents are concerned, these documents are in different names. Each document leads one to suspect the other document.
Your suit is of which year, Mr. Sen?
Which one? 2015.
15. Very.
Ejectment suit number 96 of ejectment suit number 96 of 2016. 2016. Lord, the ejectment notice is of 2015.
96 which court, Mr. Sen? Can you tell?
Yes, Lord. This is Lord.
Civil Court Chief Bench.
Lord, this is a small causes court, learned judge, 4th bench.
Maybe later part of the year also.
No, it is declaration injunction. So
the small causes court.
Now it's been transferred to the learned judge, 2nd bench. The order number 18, 38 of 8 December 2022.
What is the relief sought there?
Ejectment of R.N. Roy and Brothers represented by those 4.
Oh, that suit, the plaintiff should. Very well, yes, yes.
Now, Lord, to come back to the only document, which was the certificate of enlistment, Lord, your Lordship has been made over the judgment of Justice Jointo Vishasha. I have a copy for your Lordship's convenience. Your Lordship has got that?
It is there. It is there. I have it.
Now, Lord, in paragraph 4,
give me half cents. Auditro. এই যে জাজমেন্ট গুলো আছে না এগুলো সব বার করে আলাদা করে দিয়ে দিও yes thank you. These were cited by you Justice Satyabrata Sinha and
at the ad interim stage. Your Lordship has recorded in the ad interim order.
Yes, right.
Lord, in paragraph 4, his Lordship goes into 2 aspects. One is the effect of a trade license, and secondly, whether an occupier includes a person who forces himself into possession. The second aspect was then the right law, but after 2011, this has ceased to be good law. So I'm not relying on the second portion. I'm only on the first sentence of paragraph 4.
Very good, yes.
In my view, the trade license does not make the petitioner an occupier or a lawful occupier of any part of the premises. On payment of requisite fees, anyone can obtain a trade license from the corporation.
Unless they say that it's the occupier, an occupier has been equated with lawful occupant by using the or. I mean, interchangeably used. Then lawful occupant comes in and special judge decision comes in. Special bench decision comes in.
Lord, that cannot be, Lord, in view of the clarification made, Lord, in the explanation to the rules of 2006.
No, that is always there. That argument
that has been relied upon in the special bench also.
Yes. That has been relied on, but diluted somewhat.
Yes.
A lawful in the sense settled
possession.
Settled possession. Right, right.
No, yes. No modicum of doubt that physically he is there. Physically he is there, uninterrupted to the notice. It is not, Lord, sporadic, continuous, and for sufficient period of time to show acquiescence. These are all, Lord, in the special bench's judgment. Acquiescence, what is there? Your Lordship will
Trade
have to
license
take.
definitely does not show
I'm not-
one is in lawful occupation.
No, no, no.
Lawful cannot be shown.
Lord, Justice Shotrapato Sinha's judgment says that he will carry on business. That is for why he has taken the trade license. If your Lordship takes the other judgment,
Yes.
your Lordship has the other judgment, your Lordship.
Yes, yes,
Lord,
absolutely.
please come to that. No? Whatever. Lord, please come to Lord.
Paragraph 6, you please. tell.
Paragraph 6.
Yes.
The scheme and purport of the Act clearly envisages that a certificate of enlistment has to be obtained only by a person who is liable to pay tax. An application for obtaining certificate of enlistment is to be filed within a period of 90 days from the date when a person has become liable to pay tax. It is therefore clear that a certificate of enlistment is not necessary to be obtained before a person starts his profession, trade, or calling either in the premises or without a fixed place of business. Thus, while a person files an application for grant of certificate of enlistment, the same must be held to be for a limited purpose. Only because a certificate of enlistment is granted, the same does not mean that a license is granted in his favor to carry on business. The right of a person to carry on a particular type of business, or the question as to whether the business carried on by him in the premises in question is in violation of other provisions of the Calcutta Municipal Corporation Act or other law for the time being in force, is deholds the said provisions. It is true that subsection 3 of section 200 of the Act contemplates holding of an inquiry, but the bare perusal of the said provision together with other subsection of the said provisions leaves no manner of doubt that such inquiry is required to be held for a limited purpose. That is, inter alia, for the purpose as to whether the contents of the application are correct or not. In my opinion, inquiry contemplated under subsection 3 of section 200 of the Act does not envisage a detailed inquiry, and particularly inquiry relating to legality or validity of the right of the person applying for grant of certificate of enlistment or
But
otherwise.
one of the contents of the application is possession. That address.
That they shall use it for business purposes.
Yes. But
Within
the
90 days that they're using it for business
contents of the
purpose.
application are correct. At
No.
least that inquiry is there. Presumed.
Not a rebuttable presumption.
Definitely.
And Lord, I've shown the documents which I've obtained from the Kolkata Municipal Corporation as the foundation, the basis for on the basis of which they've given the enlistment certificate. Subsections 4 and 5 of section 200 contain penal provisions which also indicated an application for certificate of enlistment is required to be filed so as to enable the concerned applicant not to invite the penal provisions as contained therein. In this view of the matter, in my opinion, despite the grant of certificate of enlistment, it is appropriate for the authorities of the Kolkata Municipal Corporation to take a suitable action as against a person who has violated other provisions of the Act. Similarly, a landlord, or for that matter, any other person who has objection to the petitioners carrying on any business in the premises in question, will not be debarred from doing so before a proper forum only because a certificate of enlistment has been granted. So, Lord, it really says it's neither here nor there. This doesn't say anything more.
Yes.
Lord, but Lord, so far as the certificate itself is concerned, now before your Lordship can see on what basis the certificate has been issued.
Yes, you are producing that also. The RTI and
The RTI says the rent receipt issued by a dead person, and Lord, the trade license which shows license business starting on 31st of August 2023. Now, Lord, so far as Lord, the certificate of enlistment is concerned, Lord, even if your Lordship takes it to be a public document, it is a public document which is required to be proved. That exemption is not there, Lord. This is Lord, even if it was being exhibited in a civil suit.
At the evidence stage.
At the evidence stage, naturally. Your Lordship was pleased to ask me, inquire whether this would go in without proof. But this is a public document which requires proof, Lord. Lord, the section 74 lists which are public documents, and there are 78 mentions documents which public documents which require proof. This is one of such. Now, Lord, what was argued day before yesterday by my learned friend is that nowhere in the affidavit in opposition have been disputed Krishanu Bag and Tulsi Bag's blood occupation of the premises. So, Lordship desires, I made a list of the paragraphs and the page numbers where that is indicated. Lord, I don't want to unnecessarily take your Lordship's time, but it is there. I can just indicate very briefly to your Lordship. If your Lordship
Mr. Shen, can you just file a half-page, one-page note, just indicating the page numbers wherever?
Yes,
and just the points, bare points. That will. I've taken my notes.
Yes,
but just the bare points.
Yes,
if I lose track of one of them.
No, these are my respectful submissions. My respectful submission, the precondition for invoking writ jurisdiction, Lord, my learned friend has failed to satisfy Lordship.
Settled
That
possession.
is settled possession.
Thank you.
Deeply.
Yes, Mr. Jha.
May I please, Your Lordship?
How settled is your possession?
My lord. Well, insofar my possession is concerned, Your Lordship, I have demonstrated from the document of 68 as well as 71 that Shopun Bagh was already.
Shopun, who was Shopun Bagh? We don't have anything on that.
My lord, we don't have anything on that, but Shopun Bagh is in possession of property.
Some Bagh was in possession.
Of
Mr. Shopun Bagh.
211 Acharya Prafulla Chandra Road. This is the premises where the electric meter has to be installed. From the documents, the address is showing that Shopun Bagh, who is shown to be the proprietor of R.N. Roy and Company, was in possession.
Shopun Bagh does not come here in the picture at all. Who
R.N. Roy?
Shopun Bagh was some Bagh. That is the only
He's the
similarity.
proprietor. He's the proprietor of R.N. Roy and Company.
Yes.
Because here the cruxes are whether R.N. Roy Company has some bearing on this particular property and the present partners of R.N. Roy brothers, whether they are in possession of the property or not.
You have to show that you are in possession.
I am in possession.
Because this is electricity connection.
My lord.
You have to show you are in settled possession.
My lord will come to page 11 of my reply, which is the food license. Mrs. Roy, R.N. Roy and Company, and the partner's name, page 11 of my reply, my lord.
Yes, 11. Tulsidas Bagh, you were also there.
Tulsidas Bagh was one of the partners. Shopun Kumar Bagh is the partner number 1.
Oh, right. Very good.
Now, the other partner of the present partnership firm, that is R.N. Roy and Brothers, that is apart from Tulsidas Bagh, is Krishanu Bagh, who is the son of Shopun Kumar Bagh. The Lordship will refer to the partnership deed, which has been annexed. The Lordship will find that the second partner, Krishanu Bagh, is the son of Shopun Kumar Bagh.
Very good.
That is page 16 of the
Krishanu is not a party here.
Krishanu, it has been represented, the writ petition has been filed by one of the partners and the partnership firm.
Krishanu is not a pro forma respondent.
He's not a pro forma respondent. He's not a pro forma respondent. And your Lordship will find the name of the company is R.N. Roy and Company. Why I'm emphasizing on this particular aspect is that your Lordship, in the writ petition, the rent receipt which has been annexed, which was issued in the year 2015 by the respondent number 3, my lord, has been issued in the name of R.N. Roy and Brothers, not Company. Your Lordship will come to page 13 of the writ petition. Why I'm placing this is whether it was within the knowledge of the respondent number 3 that Krishanu Bagh and Tulsi Bagh had already entered into this particular partnership business and they were carrying on the business and were in actual possession. In 2015, your Lordship, page 13, it is received from Ram Nirikhan Roy and Brothers, not Company. So it is well within the knowledge that Ram Nirikhan Roy and Brothers are there. And from this document, Tulsi Bagh was already in possession in 81, being a partner of R.N. Roy and Company. And Shopun Roy's son, Krishanu Bagh, is a partner here. The Lordship, next document which I'll show is the trade license, not of 22, but of 2016. Lordship, that is at page 14 of my reply, page 14. At that point of time, Tulsi Bagh and Krishanu Bagh.
This is 2016.
2016, page 14 of my
After they filed
reply.
the suit.
After this is your Lordship in
16th
of February 2016.
Yes.
I don't know the date when it was filed.
Yes, very good.
So, my lord, the name of the firm is R.N. Roy and Company here.
Yes.
And the partners are Tulsidas Bagh and Krishanu Bagh. So the possession of these two persons, Tulsidas Bagh and Krishanu Bagh, is already, it bears testimony from this particular document, my lord. And they were in possession all throughout.
But you were interchangeably representing Company and Brothers.
Now, in the year when the earlier connection was not provided, despite the payment, and there being certain issues, we have been in possession. It is not that we were not in possession of that particular shop room. We were all throughout in possession of the shop room. And in 2022, when we contemplated to reconstitute and start the business, had it been in the name of Roy and Company, the question of new connection wouldn't have come. So they reconstituted. The fact that R and Roy and Company were represented by the two partners.
But then why
taking
were the
trade
rent receipts
license.
issued in the name of brothers in 15?
In 15, they continued in the name of R and Roy and Company.
No, but receipt was issued in the name of brothers.
Brothers, because they had already contemplated to change the name of the firm into R and Roy Brothers. They had not executed any partnership deed. Electric connection was not there. A number of issues were there for which the name was not there. But it was well within the knowledge of respondent number 3 that they were in possession of the particular premises and they had contemplated to start a business in the name of R and Roy and Brothers. And they had paid the amount to the respondent number 3, which is, as they had not paid by way of check, I cannot disclose that it was paid
How
by
do you
cash.
link Tulsidas Bagh with their knowledge? Anything in the name issued in your name by them?
It has not been issued in my name, but
Nothing
it has
has
been
been
issued
issued
in the name of R and Roy and Brothers.
Mr. Shen is also arguing on the knowledge, their knowledge. It has to be within their knowledge.
My lord,
Surreptitiously, if you make any
my lord,
prepare any-
what my learned friend is on that R and Roy and Company was the original tenants.
third limb of the special bench. Yes.
R and Roy and Company were the tenants, but I find from the suit that the defendant is R and Roy and Brothers. It has been represented by Roy's as the partners. From 68, if a person is in possession, in 81, that proprietorship firm converts into a partnership firm. Am I to believe that the owners, the landlords, were not aware of the fact that it has been reconstituted and they left me enjoying that particular premises without any rent and without my possession? They were silent all throughout.
Your name does not feature in the suit.
My name does not feature in the suit.
Your possession is disputed.
My possession.
Roy's were there, they're saying consistently.
Roy's were consistent, they're saying, but from the documents I'm saying, showing that from 68, the Roy's who have been named in the suit were no one at that particular point of time.
Very well. Very well.
So the fact of that I am in possession bears from these particular documents that R and Roy and Company in 2016 were represented by the partners Tulsidas Bagh and Krishanu Bagh. The rent receipt in 2015 was issued in the name of R and Roy and Brothers, not R and Roy and Company. And even the trade license which has been issued in 2020, without going into the fact whether the document which was produced or handed over to the authority for issuance of that trade license was a forged document. I'm not on that. They have remedies for that particular thing. But the fact that we were in possession all throughout, it bears out from this particular thing. In 68, we were in possession, 81, it continues till today. My lord.
Yes.
So in view of the fact that we are in possession of that particular premises, my lord, there should be no impediment in the license, in the CSC to inspect and install a new electric meter. And the fact regarding the knowledge of the owner is also negated from the fact that rent issued in 2015 has been issued in 2015 in the name of R and Roy and Brothers, who are the partners of this particular firm, Tulsidas Bagh and Krishanu Bagh.
Yes, but your partnership is of 2022.
My lord, the partnership, no formal partnership deed was executed. We contemplated to continue a business in the name of R and Roy and Brothers.
You've made out that case anywhere.
My lord,
you have made out that case anywhere in your
that has not been pleaded anywhere. It's based on the submission that my learned friend has made. I'm replying to that, my lord. So the existence of Tulsi Bagh and Krishanu Bagh dates back to 2016, bears from this particular document itself, my lord. And the fact regarding whether an unregistered firm can, or one of the partners can take out the writ petition or not, my lord.
I will not argue that.
Then I'll not go into that, because that is settled position and judgment is there that it is maintainable. Writ petition is maintainable.
Look, page 14 of the affidavit in reply, which is being shown. I'm sorry, I missed it out. This is a rent. This is page 14.
Yes.
Application. This is not the receipt. This is not the certificate of enlistment.
No.
This is not the trade license.
The receipt for certificate.
There's only payment being made. Well, anybody can from the street can walk in and make payment. Neither corporation nor lawyers refuse any payment.
But they did it. They did it in 2016.
2016.
The name of R and Roy and Company. Writ petition is R and Roy and Brothers.
Yes.
Writ petition is R and Roy and Brothers.
Precisely since we were making an application for a new
Other than
connection. and
company
new
in
partner-
rent receipts, it may be interchanged.
Very important, Lord. The R.N. Roy and brothers,
The meter was in the
I
name
was
of
the landlord. Every day that every other month it will be company and alternatively maybe brothers. So I find it difficult to tally my own signature. That's why that's one of my problems. So now I have to. Otherwise, it's very difficult. So that's why these brothers and company
Company.
conundrum in the receipts may not be a major factor.
But the Roys were not there.
Unless it's a
it
suit.
itself.
It's a
My
suit,
lord.
yes, definitely.
Lord,
It was
Your Lordship will
evidence.
find name of proprietor, partners,
Partner.
directors, managers, Korta, partners, Krishanuda Bagh and Tulsi
Tulsidas
Bagh.
There are several. They are appearing in
to a
several
20
avatars.
in
Once proprietor, once.
different hats. Different hats.
Yes.
No, Swapun Bagh was the proprietor.
Oh,
But
sir.
but
In 81,
but in
it constitutes
It was the
into a
father of
firm.
Krishanu.
Father of Krishanu,
Not
Swapun
a
Bagh.
party here, but a partner. now.
But a partner now, and
partnership video like-
Tulsi Bagh is there
Lord,
as a partner.
I'm not on the interchangeability of company and
The fact
brothers.
of possession.
Lordship
I'm
Lordship
There
can
is
take,
discrepancy.
it's interchangeable because of various reasons.
Maybe,
Now,
maybe.
I'm not on that.
Yes.
I'm on the different issue. Lord. This says that Krishanu Bagh and Tulsi Bagh are the partners of R.N. Roy and Company, assuming it's R.N. Roy and brothers for sake of argument. But I'm not abandoning that. But for since your Lordship inquired from me, R.N. Roy and brothers in 2015, 2016. The document by which the partnership firm is constituted is of 2023.
Yes.
2022, 31st August 2022.
Right.
So this firm did not exist in 2015, 2016.
But the persons who were there, who were
In
persons
law,
who were in possession.
in law, there cannot be a partnership firm without a document in writing. A partnership firm by oral agreement is not permissible in law.
That is the question which can be
Partnership
addressed in this
may not be in existence, Mr. Shen, validly, legally, but they are trying to show that only they were in possession. In some manner or the other, something is there prior to indicate that they did something with regard to the property, which is contemporaneous with your.
The Lordship takes the worst case scenario in 2015, 2016.
Yes.
2016, 2017, 2017, 2018, 2018, 19, 20, and thereafter.
That's there. That's there. True.
Today, when your Lordship is considering the matter,
that sporadic things comes in.
Sporadic, intermittent. And today, special mention must be today in settled possession. We're not turning the clock back and giving electricity in 2016.
Even today, we are in possession.
Certificate of enlistment, which you have disputed.
The manner in which the certificate of enlistment has been obtained, which has been put to question, that can be agitated in a different forum altogether.
Then we'll
that cannot stand. That cannot
We'll
stand.
come back after the suit. We'll come back after the decree.
even if the
Because
electric
today
meter,
your Lordship is
even if
conclusively deciding
even
whether it's in settled possession.
even if I'm
For purposes
evicted
of
from that
electricity.
particular place,
Even purpose of electricity connection, if
that will not come.
if the WBSCDCL does, if the CSC does not have that power, I am sitting in jurisdiction over what they can do.
No, your Lordship is deciding that today he is in settled possession.
Only for the purpose of electricity.
My lord, only for the purpose of
electricity. Yes,
that does not
does
create
not
any
necessarily mean that I'll go
Wait,
against you. I mean,
No.
just for argument's sake.
No, neither does it mean that, nor does it mean it creates
No,
any
no,
equity
neither
in their
does not
favor.
create exactly.
It doesn't create any equity in
Equity
law
in
in
my
their
favor.
favor either.
That cannot.
But today that they're in settled possession, as of the month of April 2023.
We rest our submissions, my lord.
Take this one. Yes, absolutely. Why not? You have to say you have to.
Hello?
Entire episode, but the thing is that we could not hold the inspection.
Mhm.
There was a padlock, so we could not hold the inspection. We have to assert it in case we have to, because there's a 15 years old meter which we have to remove and we have to give a new connection.
True.
At all. So
But
for
Ms.
that-
Mitro, the reason why I did not direct an inspection prior to hearing the matter was that you have no jurisdiction in law to decide possession. I mean, that would be a very risky proposition.
I mean, the meter
That would be empowering with something which you don't have under the law. That is the reason. So undoubtedly, if there was an inspection, something would be found out.
And my
I
lord,
don't want to see that.
one thing I must point out, my lord, that the meter room is not within the premises, the tenanted premises.
Please
It is
go to
outside,
Maybe.
which is under the possession of respondent number 3, which is not being
You
opened.
have
by
to be in settled possession of that property.
My lord,
This
my
much.
lord.
Meter room, wherever they will
That's
decide.
exactly, my lord.
Today.
As of today. As of the date of application, my lord.
Today.
Very well. At that stage, you have to start. If they win.
to find it out and thereafter whatever.
Really.
তোমরা তো কোথাও ইলেকট্রিসিটি দেওয়া হচ্ছে, সবই লোডশেডিং হয়ে যাচ্ছে, আবার ওই দিচ্ছে, দেবে কেন?
Heard learned counsel for the parties. Hearing is concluded. Judgment is reserved.
Deeply obliged. We are deeply obliged.
Thank you, sir. Judgment উপরে দিয়ে দেবে, দিয়ে কানেক্ট করো। সবচেয়ে সুবিধা ওটাই। আর ওই কেটে দেবে।
If your lordship could, sir.
Need not. Leave it. I've gathered the points. কি গো?
না না তোমারই
এটা কি করে দিয়েছে কারেকশন?
স্পেসিফিক নেই পিটিশনের মধ্যে। সেটা আসতে পারেন এদিকে।
কাকু ম্যাটার
17,
Well, in this matter, I am appearing on behalf of the petitioner,
I'm
ma'am.
for the electricity board, my lord, WBSCTC.
yes.
Malad, here the petitioner,
What
Malad,
is this?
This is the affidavit in opposition, my lord.
later the opposite.
Yes.
Malad, the petitioner is the poor cultivator and he is obtained electricity for submersible connection in the year 2000 as unmetered. Thereafter, my lord,
Unmetered connection.
unmetered.
temporary?
Since, no, my lord, thereafter I am coming. My lord, thereafter repeated request, they
Yes.
did not give the meter till the order of this honorable court. My lord, and in this way, the distribution company to raise the bill, and the bill was paid by the petitioner. All on a sudden, 2000, and my lord, thereafter several requests had been made by the petitioner to give meter box, but my lord, they didn't do. Thereafter, my lord, all on a sudden, 2014 October, he has raised a bill, the distribution company raised a bill of rupees 61,502. Thereafter, he was not in a position to to submit the amount before the electricity board. The line was disconnected. However, he was poor cultivator. That's why, my lord, on taking loan to rupees 50,000 was paid on 19th December 2014. Thereafter, my lord, line was reconnected. All on a sudden, after 1.5 months, that is, my lord, February 2015, after getting 50,000, to February 2015, another bill was raised of 1,61,588 or something, my lord. He was not in a position to make payment. Thereafter, he lodged a complaint before the RGRO. RGRO did not do anything. Thereafter, my lord, 156(1) notice was served and line was again disconnected. Thereafter, my lord, he made before this honorable court make repetition, and as per your lordship, kindly see the order of the honorable court, page 18. Page 18 of the writ petition.
Yes. Yes.
My lord, your lordship, kindly see. According to the second paragraph, my lord,
Yes. Yes.
according to the petitioner, no meter has been installed and charge levied for unmetered consumption. Restoration is also sought. My lord, thereafter threefold orders is there. Restoration can be made in the event the petitioner deposit 50% of the outstanding dues without prejudice to the rights and contention in respect of billing dispute raised, reconnection charge be also paid, and on receipt of the aforesaid sum, restoration be effected within 48 hours thereafter. Aforesaid sum restoration be effected. Thereafter, second part, my lord, RGRO, CRGRO, that is RGRO. RGRO is directed to dispose of the dispute raised before him within 4 weeks from the date of receipt of this order. And in the event no meter has been installed, steps be taken by the respondent number 4 to install such meter within 2 weeks from the date of receipt of this order or compliance of formalities, if any. There are threefold order. My lord, in view of the aforesaid order, my lord, I was not in a position to make about 80,000 rupees. My lord, I was not, but my lord, they also, my lord, no, did not reconnect the bill. Not only that, the meter was not installed. My lord, thereafter, we have.
She did not pay the 50%. Could not
No,
pay rather.
could not.
Yes.
I could not pay at that
Very
point
well.
of
Yes,
time.
yes.
Thereafter, my lord, on 5th of February 2016, my order was not complied with. We have we initiated contempt proceedings.
You have not complied.
My lord, because my lord, there are threefold
Oh, acha,
order.
other.
For
RTR
other,
did not.
I didn't want restoration, but my lord, regarding meter and also the complaint.
RTRO direction, yes, compliance. But if there is no electricity connection, where is the question of
My
this
lord,
becomes
my lord,
infructuous?
electric connection disconnected, but my lord, not entire withdrawn.
Very well then.
Thereafter, my lord, after proceeding initiation proceedings, the RGRO disposed of the complaint.
Yes.
And after complaint, he has given advice that to make an application before the ombudsman. And accordingly, on 30th February, application made before the ombudsman. My lord, your lordship, kindly come to page ombudsman's order. My lord, page 41. When I start, my lord, page.
Previously, yes.
Regarding, my lord, your lordship, kindly see page 41.
Yes.
Regarding the submission of the OP in paragraph 1 of their comments, it appears that they have raised to establish therein that the Honorable High Court has already considered the merits of their claim, which created the grievance of the complainant. In WP, my lord, this is the order of justice. No, my lord, this is order of justice, Horish Tandon, in the same cause of action. My lord, and directed the petitioner to pay 50% of the outstanding dues. No, my lord, it is in my lord, right, my lord. This is Justice Pathetia's order. Dues in LPSC for dealing with the said submission of the OP, let the submission made by the OP in their formal report submitted to this forum by memo number such and such to consider first, where they themselves have admitted that the order passed by the Honorable Court on 31st March of 2015. Restoration can be made in the event the petitioner deposited 50% of the outstanding dues without prejudice to the rights and contention in respect of billing dispute raised. Reconnection charge be also paid, and on receipt of the aforesaid sum, restoration of the connection will be made within 48 hours. Thereafter, my lord, such and such make payment. Your lordship, kindly come to page 42. In view of what have been discussed at paragraph 49 to 53, I do not find any justified reason to make any amendment in the draft settlement order at the time of finalization. Hence, final order is passed in terms of regulation 10.5 of the West Bengal Electricity Regulatory Commission. Guideline by such and such. Though, my lord, regulation due 2013 as follows. My lord, that the order passed by the learned RGRO on 16th of December 2016 in respect of the grievance petition submitted to him by the complainant is set aside.
The RGRO had went against you.
Yes.
So that is set aside.
That is set aside.
Yes.
That the OP, that is, my lord, WBACTCL licensee company shall cancel their claim of LPSC against the service connection of the complainant amounting to rupees 1,37,938 only against the bills for the period from January 2006 to January 2014. My lordship, kindly mark it. As it has been established that the said amount has been claimed in total violation of section 56, subsection 2 of the Indian Electricity Act. Thereafter, my lord, that the OP, that is WBSEDCL, shall regenerated the electricity bills of the complainant for the period from January 2014 to the date of disconnection of service line of the complainant on actual consumption basis as per norms and for the period of 180 days beyond the date of disconnection. He himself, the OP has himself, distribution company has himself asked that the date of disconnection is 10th of March 2015. And my lord, that is shows, my lord, page 31. And my lord, thereafter, my lord, of 180 days beyond the date of disconnection, in terms of regulation 4.10 of the West Bengal Electricity Regulatory Commission Supply Code, if the bills for the aforesaid period were generated at all earlier. Thereafter, my lord, that in case any such generation was not made earlier, the OP, that is WBCSEDCL, shall generate the bills for the period as specified above in the manner as mentioned therein. Thereafter, my lord, ordered one that the above exercise for cancellation of claim of LPSC regeneration or regeneration of the bills are to be completed within a month, and the formal communication regarding cancellation of the claim LPSC and the bills are to be sent to the complainant within next 7 days. My lord, they did not do anything. Thereafter, my lord, I have proceeded, contempt application was heard on, my lord, on 10th of October 2018. Your lordship, kindly see page 44. Next page, my lord.
Yes.
My lord, your lordship, kindly see. See, contempt application 188 Sachan was filed, and according to the petitioner, the alleged contemner respondents violated the order dated 31st March 2015. The matter was considered by the ombudsman and order was passed on 7 June 2018. The order of the ombudsman has not been challenged by the petitioner. It will be by the respondent. And by the said order has been complied with by the WBSEDCL and or the alleged contemner. Respondents, your lordship, kindly mark it. Respondent by its bill dated 9th October 2018. That bill was submitted before the Honorable Court, and on a perusal of the said bill dated 9th October 2018, it appears that LPSC has been waived as directed by the order dated 7th of June 2018. The balance outstanding dues minus LPSC has been set out in the letter dated 9th October 2018, and the said is set out herein below. Well, that is the LPSC is such and such has been waived. Thereafter, my lord, to the total outstanding, my lord, this is the main point. The total outstanding dues without LPSC for the period of January 2006 to 2014 is rupees 677. B, for the period February 2014 to the date of disconnection of service is rupees 30,478.51. And for the period of 180 days, 10,513. My lord, thereafter, on perusal of the said bill, the Honorable Court was pleased to direct me to 50% of the said amount within a week. Thereafter, 50% within, my lord, within 4 weeks from the date, and my lords, accordingly, first installment was paid on 11th of October 2018, and meter was also at that point of time installed 15th of October 2018. Thereafter, another second installment also paid 3rd of November 2018. And my lord, thereafter, my lord, thereafter, my lord, your lordship, kindly, my lord, thereafter, my lord, or the in spite of that, my lord, in spite of repeated requests, thereafter no bill had been raised by the WBSEDCL in spite of repeated requests to send the phrase bill according to month. But my lord, they didn't do anything. Thereafter, all on a sudden, after 1 year of this order, after 1 year, 2019 December, another bill was raised that, my lord, this is the impugned notice. Your lordship, kindly come to page 52. My lord, he has raised the bill, my lord. Your lordship, kindly see the next page is, my lord, typing. My lord, your lordship, kindly see the previous reading date 21 November 2015, current reading date 12th of October 2018. My lord, your lordship, kindly see. Billing date, your lordship, kindly see the 30th October 2019, and my lord, bill month October 2018. My lord, he has given the bill, my lord, above on in bill month of 2018 October, after 1 year. And my lord, when the bill was paid as per honorable court's order. My lord, your lordship, kindly see the order of the honorable court. The entire payment has been made in the year 2000 October and November 2018. Thereafter, again, the bill of October 2018 raised in the year 2019. We have made objection, and my lord, your lordship, kindly see. There are several orders there, and my lord, thereafter we have made we challenged the bill, and my lord, this writ application. And you not only that, my lord, your lordship, kindly see where
They have not given a meter till now.
No, meter. Thereafter, my lord, meter was, we have given later that meter was not good, and it not shows the meter consumption. In the year 2021, we have lodged a complaint before the WBCDCL, but they didn't do it. After your lordship's order, they made another meter. Correct meter was he has given.
Your dispute is only regarding this month,
regarding this
month of October
2019.
And now you are enjoying the electricity connection otherwise.
Yes, my lord. And we are paying. My lord, your lordship, kindly see my
Current
reply.
charges you are paying.
Yes, my lord.
Very
Yeah, we are paying that. Not only that, after your lordship's order, they another bill generated before with this amount. And my lord, we have your lordship, kindly see the reply. Copy. Your lordship, kindly see page. Page, my lord, 2. Your lordship, kindly see.
Yes.
The Honorable Court's order dated 23rd December 2022 was communicated to the respondents by letter dated such and such, along with the server copy of the order through the learned advocate on record, which was received by the respondent number 2 and 3 on 3rd of January 2023 and 4th of January 2023 respectively. And in spite of receiving the said order, the respondents, by disobeying the said order and reluctantly sent a bill of bill month of January 2023 on 26th of January 2023. That bill was sent back. Thereafter, as per my learned advocate's consent, they have taken the rest of the amount. And that is my submission. This is main dispute is, my lord, January and October 2018.
That is the only dispute.
Only dispute.
Yes, what happened?
My lord, kindly
Please take your seat, Mr. Rachudhary. I'll just you also.
My lord, kindly comes to page 45 of the writ petition, my lord. On last occasion, my lord was pleased to hear this matter, and
yes, 45.
Yes, my lord. My lord, in this order, my lord, the total outstanding due, point number 2, without LPSC for a period of January 2006 to January to 2014, it's rupees 677. This total figure amounts to around 41,000 rupees. My lord, this 41,000 is the amount from January 2006 to February 2014 and 180 days beyond the disconnection. My lord, from 2015 or from after February 2014, 180 days till, my lord, 2019, my lord, we claimed energy charge, my lord. Kindly comes to the disputed bill, my lord, once, page 53.
Which year to which period? For which
My lord,
period?
the previous reading was 2015 and next is on 12/10/2018. My lord, this period, my lord, kindly comes to page 53 once, my lord.
Yes.
My lord, this is the disputed bill which my learned friend is claiming. My lord, this amount payable is rupees 6,994. This bill, my lord. My lord, this in this period they didn't have the connection, my lord. Now this connection was disconnected. However, my lord, I have given a categorical explanation to that. My lord, this amount is the energy charge, my lord. Is not the energy charge, it's a demand charge, my lord. Kindly sees the left hand portion, my lord. Energy charge is rupees 00. The left hand portion of the bill, my lord.
Yes.
The energy charge is rupees 0.00. Fixed demand charge is rupees 6,551. Along with that, some area demand charge and the government subsidy included 6,294. That is the total amount, my lord. My lord, may I just peruse my affidavit in opposition, my lord? Kindly comes to page 4 of my affidavit in opposition now.
They are running a submersible pump with this.
Yes, my lord.
So why fixed demand charge?
My lord, that is because the connection was never disconnected. Because it was deemed disconnected, it was not permanently disconnected, my lord. My lord, kindly comes to my affidavit in opposition once.
Yes.
My lord, paragraph 11 of my affidavit in opposition. My lord, the second sub-para of paragraph 11, my lord, the answering respondent state, have my lord found it?
Found.
State further that the period from 21/11/2015 to 12/10/2018, service connection of the petitioner was not permanently disconnected. In case of permanent disconnection, the WBSEDCL dismantle all electrical infrastructure like service cable, electric energy meter, transformer, etc. from the consumer premises and discontinue his contract from WBSEDCL by raising a final bill adjusting the security money deposited by the consumer. In this case, my lord, it was not permanently disconnected. My lord, the next para, my lord, the very next sub-para, the answering respondent state further that in this case, service connection of the consumer was disconnected due to non-payment of his previous outstanding bills. So his connection became deemed disconnected. In these cases, the WBSEDCL does not dismantle the electrical infrastructure from the consumer premises, so that if he wants to continue his service connection anytime after clearing the previous outstanding, and the WBSEDCL can reconnect the service line in the same infrastructure without any security money and new service connection charge. After reconnection, the WBSEDCL raised a bill only for fixed charge for unmetered connection as per the tariff order of WBSEDCL in deemed disconnected period and no energy charge claimed during this period, my lord. My lord, for this period, my lord, rupees 62,994 rupees was claimed. This was because of the fixed demand charge, not because of the energy charge, my lord.
What is the occasion to charge fixed demand charge?
Because, my lord, they were constantly maintaining all those electrical infrastructures, my lord. The connection to this person's was
Why
not.
should they pay for that? I mean, yes, you were maintaining the connection. You could have disconnected. You had the option. You are maintaining in the anticipation that he would be seeking reconnection. If he did not, then could you have charged this amount from him?
No, my lord.
I mean, otherwise, because liability has to be both ways. I mean, they are required to be liable to pay some amount. You incurred the charges, I'll take you on your face value, definitely, because you must have. But if you keep that in anticipation that they will come someday and apply for reconnection, I mean, why should they pay for that? And fixed demand charges, sometimes there is an agreement between big industries and the licenses regarding these fixed demand charges. There will be, because they have to maintain an infrastructure for these big businessmen or industries. For that infrastructural charges, they do charge. But in this case, it was never charged. There is no agreement to charge. It is defaults the law.
My lord, in that case, my lord, I need to take further instruction maybe because this is what
question.
the instruction which I've received, my lord. That
No, that's a correct instruction. I mean, I'm not disputing the instruction at all. So I'll decide this against you. I mean, against the WBSCDC on law. You have argued well, but
Yeah.
the merits of the matter is not in your favor.
my pleasure, my lord. But my lord, the entire amount was around something around 1,25,000 because from October 2018 they had been enjoying the electricity connection which was reconnected. But
If the fixed demand charge goes, then these dues do not arise.
no, the rest of the amount they have paid, my lord.
They have paid.
They have
yes.
paid subsequent to my lord's order, my lord.
Right, right.
The pay
For
subsequent.
which the no, they gave it. Very well. The plinth of the dispute in the present litigation is, please take your seat. You are Mr.
Asif Diwan.
Diwan.
Yes,
Mr. Diwan, take your seat. The plinth of the is the bill raised by the WBSCDCL for the month of October 2018. Full stop. Next para. Such bill is annexed as Annexure P5 at page 53 of the writ petition. Full stop. Next para. Learned counsel for the petitioner submits that there was a checkered history in the matter, comma, which culminated in the matter being decided by the Ombudsman in favor of the petitioner. Full stop. The order of the Ombudsman stipulated that the RGRO order dated December 16, 2016 was set aside and the WBSCDCL were to cancel their claim of LPSC against the service connection of the complainant stroke petitioner amounting to rupees 1,37,938 oblique dash against the bills for the period from January 2006 to January 2014. As it had been established that the said amount was claimed in total violation of section 56 within bracket 2 of the Indian Electricity Act 2003. Full stop. Next para. The WBSCDCL was also directed to regenerate the electricity bills for the period from January 2014 to the date of disconnection. Full stop. Next para. Subsequently, an application for contempt of the said order. Subsequently, an application was levied before the concerned coordinate bench, comma, then taking up electricity matters, comma, where the court had observed that the outstanding dues were in consonance with the order dated June 7, 2018 passed by the Ombudsman. Full stop. However, comma, the petitioner was permitted to pay the said dues in 2 installments. Full stop. Next para. It is submitted that the installments were duly paid by the petitioner. Full stop. However, comma, thereafter, a bill was raised on October 30, 2019, comma, indicating that for the month of October 2018, comma, the petitioner was to pay certain charges, comma, including fixed stroke demand charge to the tune of rupees 62,551.25p. Full stop. Next para. It is submitted that even at the juncture when the coordinate bench of this court directed the petitioner to pay the outstanding dues by installments, comma, the said sum was not mentioned by the WBSCDCL in any manner whatsoever. Full stop. Since the order dated October 10, 2018 passed by the coordinate bench did not mention about the fixed stroke demand charge, comma, the petitioner does not have any further liability to pay such charges. Full stop. Next para. Moreover, comma, there is no conceivable reason why the said bill was raised about 1 year after the alleged incidence of the charges. Full stop. Next para. Learned counsel for the petitioner also disputes the very premise of the charges being levied under the head fixed stroke demand charge. Full stop. Next para. Learned counsel for the WBACDCL submits on instruction that the fixed stroke demand charges were raised by the WBACDCL to meet up the expenses incurred by the WBACDCL for maintenance of the infrastructure during the period when the electricity connection of the petitioner remained disconnected. Full stop. Next para. The premise of such maintenance was, it is submitted, that if the petitioner subsequently seeks restoration of the connection and pays the due amount, the same would be reconnected without incurring unnecessary costs for installation of the infrastructure again. Full stop. It is submitted that since such charges were incurred for the purpose of saving costs of the petitioner, the petitioner is liable to pay such amount. Full stop. Next para. There are two primary grounds on which the demand of fixed stroke demand charge, which is impugned in the present writ petition, were dehors the law. Full stop. Next para. First, when the matter was taken up for hearing before the coordinate bench and the order dated October 10, 2018 was passed by the coordinate bench within bracket annexure P3 at page 44 of the writ petition, bracket closed, the fixed stroke demand charges now demanded were not mentioned by the WBACDCL or recorded in the said order at all. Full stop. It is evident from the said order that the learned single judge had proceeded on the premise that the entire outstanding dues at that point of time were comprised of the amount which were directed to be deposited by the petitioner and was duly deposited by the petitioner. Full stop. Next para. All on a sudden, more than 1 year thereafter, the WBACDCL has raised the demand of fixed stroke demand charge out of the blue, without having any material basis. Full stop. Since such demand was not mentioned before the coordinate bench and the coordinate bench had conclusively determined the outstanding at that juncture, minus the fixed demand charge now claimed, the issue cannot be reopened by the WBACDCL by claiming such amount afresh after the lapse of 1 year thereafter. Full stop. Next para. Secondly, there is no basis or premise of charging such fixed stroke demand charges by the WBACDCL at all. Full stop. It was the problem of the WBACDCL. It was the option for the problem. It was the option of the WBACDCL whether to sustain the infrastructure for giving electricity connection in the area or to dismantle the same during the period of disconnection. Full stop. Next para. Since the WBACDCL chose to sustain such connection, the petitioner cannot be made liable all on a sudden to pay such charges. Full stop. Next para. The common practice for licensees is to fix such demand stroke fixed charges in case of electricity supply to industrial houses or concerns, where a huge infrastructure is required to be maintained for dedicating electricity supply to such concern. Full stop. However, in the present case, there was no agreement between the petitioner and the WBACDCL at any point of time to for such demand charge to be met, MET. Full stop. Next para. That apart, it is not seen from the materials on record that such demand charge was demanded at any other point of time from the petitioner. Full stop. Hence, comma, the said claim of the WBACDCL is entirely contrary to law and natural justice. Full stop. Next para. In such view of the matter, comma, there is no scope of sustaining the impugned bill of the WBACDCL. Accordingly, WPA 28422 of 2022 is allowed, comma, thereby setting aside the bill dated October 30, 2019, raised for the bill month October 2018, comma, to the extent that fixed stroke demand charge of rupees 62, 551.25 p was levied. Full stop. Full stop. I get a bracket করে দাও. The document is annexed at page for 53 within bracket annexed at P5 bracket closed of the writ petition. Full stop. Next para. Since the petitioner has already cleared the balance amount of outstanding dues and is going on paying regular electricity charges for enjoyment of the connection, comma, no further direction is required to be passed. Apart from the WBACDCL being directed to sustain the electricity connection of the petitioner subject to payment of regular electricity charges by the petitioner and compliance with law otherwise. Full stop. No rest to cause urgency.
Before your lordship rises, my lord, very next matter.
Yes.
Will your lordship be kind enough to take it up on Monday, my lord?
Who is appearing for the other side?
I'm for the petitioner.
My lord, I'm for the private respondent. My connection is being disconnected. There's already.
I'm only
Come back after recess.
My lord,
My lord,
my lord, there was a similar petition which my lord has.
I'm only
dismissed,
seeking it to be taken up on Monday.
After the recess.
No, my lord, there is, I have got some difficulty, otherwise I.
After recess.
Yeah. There is a matter fixed in 654.
Yes.
Monday.
Whatever my lord decides, but my connection is already similar writ petition. My lord has dismissed. The landlord has filed.
দেখে দাও, বোর্ডে দেখিয়ে দাও।
My lord.
18.
একটা অর্ডার রেকর্ড করো।
My lord, I am for the petitioner. My lord, kindly see the last order. My lord,
Last chance was given.
Yes. There is a.
No, since there is a dispute at 120, I definitely won't do anything. Then, Mr. Mukherjee, you have to come back up.
It's
No,
not
we
that
You have to send somebody.
We have to file the opposition, my lord. We have read.
I'll consider after this. No. Send somebody. Yes, I'll consider.
a detailed order was passed from last.
Oh, senior.
I submit, my lord. There was a direction of by your lordship to file affidavits, my lord. But I have made the affidavit, I have also served it to the petitioner. May I file? I only request, my lord, if my lord may kindly take it up any day next week.
I have also
Because
served-
এক মিনিট আমি একটু বলে নিই। Very frankly, my lord, I could not make myself thoroughly prepared in this. This is the affidavit in.
Reply.
My lord,
So it is beyond time, my lord, I have served him.
My lord, copies have not been served upon me. My lord, in brief. if
You're
I
for
could-
respondent number?
I'm for the private respondent. They have added the party here upon your lordship's direction.
It could not be served because I didn't have the address. My lord, I will serve it on Monday.
Already a writ petition, the similar case have been filed and my lord, I discussed the writ petition, my lord. Here, they are, if they want to seek eviction, they can go to a proper forum, my lord. They cannot stop my connection. They are saying that the connection cannot be restored in the name of that person.
My lord, this is
What are you
my
trying to
petition,
achieve?
my lord.
My lord,
Because your friend is in difficulty, he has got a matter there.
Yes.
He has given, if you want to proceed without the reply, then I'll definitely hear it.
No, my lord, there is no question of reply. Kindly see your lordship's last order. The private respondent was restrained to use any affidavit. There is a specific direction
Oh.
because he has no locus.
no, my lord.
Private
My lord, the
respondent-
writ petition was dismissed on.
The Shailendra Khuntela added only the liberty was given to him to
Restraint.
add him as a party because the CSC, my lord, if my learned friend has
My lord,
made his submission, then my lord, I will make my own submission. my
Affidavit
lord.
in opposition filed by the CSC Limited and reply thereto filed by the petitioner be kept on record. Full stop.
Yes.
Learned counsel for the CSC Limited seeks a day's adjournment in the matter. Full stop. Next para. Learned counsel appearing for the added private respondent vehemently opposes such prayer and submits that a previous writ petition in similar tune had been dismissed.
Same matter, my lord.
Full stop. Next para. Disputes are controverted by learned counsel for the parties. Full stop. Next para. Be that as it may, comma, since an adjournment is sought, comma, let the matter stand adjourned for the day and shall next be listed on 24th April, Monday.
My lord, only thing, my lord, if for some reason, my lord, if the matter is not taken up on 24th, my lord, I have some personal difficulty on 25th and 26th, my lord.
This is
I'm
a
available on 24th.
This is
But if some reason, if it is not taken up on 24th, my lord, then I will not be available on 25th and 26th, my lord.
Can you keep somebody to pray for time then?
Yes, sir, I will ask my junior my lord to be here.
Yeah, read with this part of the order, my
My
lord.
lord, this is my writ petition.
My lord, the
Call on the
connection-
next matter, please.
This is my writ petition, my learned friend is making. Assigned matter, item 19.
Grateful. I'm grateful, man.
None appears for the parties. Let the matter stand adjourned till Monday. Monday na kore adjourned till April 24, 2020.
Item 20.
Item 20, I'm for the respondent bank. I don't know, my lord. Kindly takes the last order, my lord, once.
Yes.
I believe a last opportunity was granted. 20 choices.
Item 20.
It's my petition.
Yes. What is the matter?
Before the matter, the writ petition, there's one amendment application, man. That matter has to be taken up first, man.
Is that appearing?
It's there in the list, man. Cantony?
My lord, if I may just.
Can't appear koche? What is the number? Has it been mentioned here?
Can 1961, because on the last occasion, my lord, I had also indicated. And
My lord, it's not appearing in the list today.
because on the last occasion, my lord, I indicated I had taken steps, my lord, for the can to come. Can taken?
Can না থাকলে ওটা লিস্টে দিতে হবে তো।
I understand, my lord. there is some difficulty in the CIS. The CAN is not being, I mean, it cannot be uploaded or something like that.
লিখে দিলে আপলোড হবে আবার কি আছে?
I don't know.
এখন তো অটোমেটিক আসবে না, তুমি তো লিখে দেবে, বলে দাও যে যেটা আমি একটা ডিরেকশন দিয়ে দিচ্ছি। And a connected amendment application is pending as per learned counsel for the petitioner. Full stop. Let such application be tagged along with the writ petition to be taken up on April 24th, Monday.
Very good. Well,
Only one thing, my lord, by my lord's last order, there is a
This was the last chance.
sword hanging on me, my lord. May that be, my lord.
It will remain hanging.
Okay. Like Sonarpur has become, my lord, Greater Kolkata, Calcutta High Court has also enlarged, my lord. It takes time, my lord. to come. At times, my lord, it's not billing that I can.
Enlarge your contingent.
Well, if I may just indicate, today Andhra Bank, which is the respondent bank appearing, which is the respondent bank that they've implemented in the writ petition, it's been merged with Union Bank. So I believe they have to carry out a substitution to that effect as well.
It can be.
Put it in the amendment application also.
The amendment application is, my lord, for bringing subsequent facts into on, my lord. So writ petition of 2011 for deciding, my lord, the writ petition, there have been a lot of.
The 24th একটু চেঞ্জ করে দেন মাধববাবু, auditor 24th না, shall be listed in the monthly list of May 2023. Full stop. Next para. Learned counsel for the bank submits that the Andhra Bank, comma, which has been arrayed as a respondent herein, comma, has since merged with the State Bank,
With Union Bank of India.
with the Union Bank of India. Full stop. Necessary corrections shall be effected by the learned advocate on record in the meantime to the cause title of the writ petition, comma, altering the name of the bank to its current status. Full stop.
May, my lord, one instance.
Do it in the meantime.
May I date, please?
Grateful.
Not monthly list, my lord. Any date.
No, no, monthly list is very short.
Well, it's been pending since 2011.
Monthly list and daily list is all the same.
I want the application to be disposed of. The writ petition can be taken up later, my lord.
Put together.
I'm grateful, my lord.
You will escape after the application is heard.
I will. The application. The
I'm ready in the main writ
the
petition
amendment
also.
will help me, my lord, in disposing of.
Let
the
us
writ
see.
petition.
Grateful, my lord.
Item 21.
Yes. None appears for the parties, adjourned till 24th. Same order. Same.
My lord, I am appearing for the private respondent.
Private respondent. When the matter is called on for hearing, comma, none appears for the petitioner. Full stop. However, comma, the private respondent is represented through counsel. Full stop. Let the matter stand adjourned till 24th.
My lord,
April
24th Monday, I have some personal
When
difficulty.
should I keep it? Tell me.
Any date except 24th.
Very well. Adjourned till April 25th, 2023.
The namtra di do.
25.
Next matter also I am private respondent. I am my lord, same prayer.
Exactly same order. 25th. None appears for the parties. When the matter is called on for hearing, let the matter stand adjourned till 24th. Same order. হয়েছে মান্থলি হয়েছে দেয়নি তো কাউকে কিছু যায় না এক একদিন এক একজন শেখো তোমার শেখানোর জন্যই এই অবস্থা এতক্ষণ দেখানো হচ্ছিল বোর্ডে একটু মান্থলি লিস্ট না অন্যগুলো দেখানো
Month list for hearing item number 84.
বোর্ডে দেখা
Item 84.
None appears for the parties who serve. This is the third occasion when the same absence is repeated. Full stop. Accordingly, WPA 14804 of 2022 is dismissed for default without any order as to cost. Interim order, if any, stands vacated. আচ্ছা এটা ডিসমিস ফর ডিফল্টটা করো না আজকে আজকে তো একটা রেজলিউশন আছে রাইট আচ্ছা যে বাকিটা যেটা বললাম থাকবে লেট দ্য ম্যাটার স্ট্যান্ড অ্যাডজেন্ট টিল মানডে মানে ডেটটা দিয়ে এপ্রিল 24th
85.
My lord, I appear on behalf of the petitioners, my lord.
What is the matter, please?
This is, my lord, regarding a matter of that lift, my lord.
Oh, that lift.
Yes, it's akin to the matter that Mr. Banerjee, Mr. Banerjee is also leading me in this matter, my lord. My lord, in this matter, I am the owner of the property, my lord.
What is your name, please?
I'm the petitioner, my lord.
Your name.
Oh, Shomujit Mojumdar.
Mr. Mojumdar, let the others come because there's a resolution from the bar association.
Certainly,
Today.
certainly.
Let us wait till Monday.
Right.
The petitioner is represented. Full stop. However, none appears for the respondents. Let the matter stand adjourned till 24th.
My lord, Mr. Banerjee is leading me. Can I put his name in that?
Absolutely. Is he in court?
He is in court.
Or gone for Eid?
No, he's in court.
86.
None appears for the parties. Adjourned till 24th.
Ninety-six, 97.
96, Lordship.
You're for the petitioner?
For the WBC resale, no.
Not for the. None appears for the petitioner, although the WBSCDCL is represented through counsel. You are only in WPA 18 to 12.
1812. 1812, Lordship.
1812. This is item 96, 97. You are in 96 or 97?
96, Lordship.
Yes, 1812.
1812, Lordship.
Although the WBSCDCL is represented through counsel in WPA 1812 of 2023. Full stop. Let the matter stand adjourned till 24th, April 24th. রামকৃপালকে ডেকে না আজকে এই বেলা কোনো আশা নেই
100.
সেম অর্ডার পাশের ঘরের লিস্টে ডাকো তো দেখ সেটা মালতি বলে দিয়েছি তো ওপেন করে এইগুলো ডেলিতে কম্বাইন লিস্ট গুলো ডেলিতে বললাম তো হ্যাঁ 24th মানে হচ্ছে ওই জন্যই বলেছি ওদিকে তো আগে মান্থলি লিস্ট কয়েকটা এইগুলো পাঠিয়ে দিয়েছি
Item number.
You are for the petitioner, it has been dismissed for default. If you are for the opposite respondent, then it has been allowed. Yes.
Sushmita Chatterjee, WBSCDC. ওই অনলাইন
দাদা দাদা
কবে হলো
100টা 24 তারিখ সোমবার
সব 24 তারিখ অর্ডার হয়েছে তো দাদা অর্ডার হয়েছে না ওই নামটা হ্যাঁ দিচ্ছে নাম নেবে না